unless your lordships, and that is not really even for a bench of 5, unless your lordships come to the startling conclusion that under 142, applications pending before a speaker can be transferred to this court and tried. And that's one of the prayers in one of the writ petitions. Or an even more startling conclusion saying the moment there is a disqualification petition filed, the candidate stands disqualified until he is requalified by rejection of the dissent petition, by the defection petition. But those are not matters, one of which 5 of your lordships will refer to 7. What your lordship is today concerned is with the Nabi Marabia problem. I will not take any time reading that judgment beyond saying that there was a serious problem in that case. There is a strong argument that you should not hold speakers to be in suspended animation merely because a removal is pending. But Justice Misra particularly, brings out the counterpoint. Suffice it to...
Justice Misra brings out the
counterpoint.
The counterpoint.
Yes. And I'm only saying this for the reason these are delicate constitutional issues which should be resolved in a fit case where the question arises. Does the question arise in this case? And the answer is a resounding no. And let me tell my lord why. It is, my lord, in our counter affidavit, if your lordship turns to page 494 of volume 1, convenience compilation. What exactly happened and what has happened and where are we today? The only petition in which Nabi Marabia today is a live issue is a petition settled by Mr. Kamath, who perhaps realizing the folly of his ways has argued that Nabi Marabia should be reversed. It's a petition by a group of people against whom the Shinde faction has filed defection petitions. They have come to your lordship saying because of Nabi Marabia, because we have applied for removal of the current speaker, do not allow him to continue. Now if they say the judgment is wrong, all they need to do is withdraw their petition. Look at that, Malad, for a minute. Because I think that's what is important to know. In such a delicate constitutional issue, your lordships are embarking on a journey which has no destination. Page 494, Malad, we give the dates.
494
of compilation 1, volume 1. Malad, PDF page 494. 497, sorry. I hope I've got my PDF pages right.
It's a common reply of the same.
It says convenience compilation volume 1.
Convenience compilation volume 1. It starts on the clock as common.
Factual matrix. Correct. That's that. Factual matrix.
Have your lordships been able to find that?
Where it says factual matrix.
One of the first sentence in that is in a sub-paragraph 7 saying on 21st June 22.
It is. Yes, Mr. Salve.
Whose counter is this?
This is Malad from our side.
Right.
21st June 22, it starts by saying it came to the knowledge of the answering respondent. Answering respondent here is the current Chief Minister, Mr. Shinde, and other members of the Shiv Sena Legislative Party. One of they have used SSLP, the acronym for that. That a minority faction, only 24 out of 55 MLAs, attended an authorized meeting, passed a resolution to remove the answering respondent as leader and appointing Ajay Chaudhary as the group leader. Then next para it says on 21st June, 34 MLAs of the SSLP passed a resolution reaffirming that the answering respondent was appointed as a group leader, etc. The resolution was clearly stated that appointment of Ajay Chaudhary is illegal. Now, this is all the wrestling going on with the appointment of the leader of the party. This is all happening on 21st June. Para 10 says on 21st June, 34 members of the Maharashtra Legislative Assembly issued notice under Rule 11 of 179 to Mr. Natari Zerwal for the motion for removal of the Deputy Speaker. Now, this motion was never carried to fruition. In fact, he continues even today as Deputy Speaker. 24th June 22 is the next event, small 11. Answering respondent came to know that Secretary Maharashtra Legislative Secretariat communicated that a request made by the petitioner to recognize Ajay Chaudhary has been recognized by the Deputy Speaker. So, the other faction's person is recognized as the Deputy Speaker. Then, 22nd June, Sunil Prabhu, claiming to be group leader, issued notice. There were cross notices to each other. Your Lordship may drop down to page 501 PDF, para 14. In a meet, so that's the number in count. Then, small 15. Accordingly, on 23rd June, Mr. Sunil Prabhu filed a petition under Rule 6 of the defection rules against the answering respondents and a few MLAs for not attending the meeting on 22nd. Now, please see the next paragraph 16 at 502. And this is why petitions are filed in this court. Forget the Navim Rabia point. Answering respondent along with few other MLAs received summons on 25th June by Principal Secretary for disqualification, etc., etc., whereby the respondent and others were directed to file a reply to disqualification petition on or before 27 June. Now, this is even against the rules. You have to give a minimum time. The speaker was rushing ahead. Then, on 26th July, should be 26th June actually, the answering respondent and other MLAs filed. Therefore, this was the original petition filed. And in this, para 18 says on 27 June, this court said we extend time till 11th July. Now, this court did not say that the speaker shall be in suspended animation. By extending the time to file a reply and by compelling these people to file a reply, the court has in fact allowed the speaker to function. Now, we were therefore given time up to by the court till 11th of July. In the meanwhile, on 28th of June, the Maharashtra asked Mr. Uddhav Thackeray, the Chief Minister in office, to prove his floor majority. And on 30th June, a session is convened on which Mr. Thackeray is to prove his majority. On 29th June, Mr. Sunil Prabhu moves your lordships asking for a stay of this session. The court declines it. When the court declined to stay the 30th June meeting, Mr. Thackeray resigns.
So there were two. The actual scenario was this. By our order of 27th of June, we had
Yes.
extended time until the 12th of July to submit
11th of July.
responses.
Sorry. 11th
The
July.
disqualification notice.
12th July.
Yes.
But in the meantime, as a result of the direction of the governor, the floor test was to be held on
Yes,
30th. In other words, the floor test would take place without the speaker applying his mind to the disqualification.
Correct. Correct. They came to your lordships and said, stay this meeting.
Right.
Your lordship said no. Now, the legality of that meeting is no longer an issue because Mr. Thackeray resigns.
This one.
So there was no meeting on 30th June. So, my lord, the question of the defected or the challenged 16 MLAs voting on 13th June did not arise because there was nothing on 30th June. Mr. Thackeray walked away. So even that question of law doesn't arise. And on that date, I want to give your lordship admitted figures. There are 288 MLAs. The BJP and the independents who support it are 115. With the
115.
Congress and the
115.
115.
All right.
So the balance 173 is the what used to be the Maharashtra Vikas Aghadi. Give or take one or two here or there. Gap of approximately 58. And there are 16 disqualifications. So it was not because of the disqualification pending petitions which tilted the result either way, and Mr. Thackeray saw that and walked away.
So the disqualification was sought against 16 totally.
Yeah, yes, those are the petitions pending. That's the figure I've not been given.
So these, according to you, wouldn't have made a difference even if their votes were to be excluded.
Even if there was a meeting in which they had voted.
Just factually, 27th June, 22 more were sought to be disqualified. Just
27th.
7th of June, 22 more were sought to be disqualified by the petitioners. Just so that the facts are before you.
Yeah,
I don't want to
I
interrupt.
accept my friends.
Any disqualification
Notice was never given of that.
Yes, yes.
1 minute. Any disqualification notice you had given?
Yes.
No,
No notice was given. Please take a.
Petition was filed. Petition was filed. That's all right. The petition was filed for 22.
This was only the initial notice.
my lord, may I?
I'm
So
just
let's
stating the facts.
the facts are clear. Our writ petition related to 16. For the balance 22 petitions may have been lodged, but the speaker took no action. On 27th June. This is when Mr. Thackeray is still chief minister. Now, in a scenario like this, if the chief minister resigns and there is no trust vote, what would have happened on the trust vote? Would these people have changed their mind in view of the pendency of the petition and supported the chief minister? Would they not have supported the chief minister? All those questions don't arise because there was no trust vote.
For their petitions to be really live petitions, that they should have faced the trust vote.
Yes, sir. Then some questions may have arisen
Voted
about
out of
what
office
happened.
on the trust vote.
Yes.
And then you would know who are the actual people who voted
Exactly.
in favor of the trust vote and who was sought to be disqualified.
That's right. None of that ever happened. Now, my lord, 30th June, let me, and my lord, one thing is clear, by now Nabim Rabi has all become academic. Those 16 disqualifications petitions are still pending. On 30th June, the current incumbent, Mr. Shinde, gives a report to the speaker showing majority. The governor directs a floor test on 4th of July.
What happened on 30th June?
My lord, the current incumbent goes and moves the governor. He's made chief minister. And on 30th June, my lord, the governor says, prove your majority within 4 days. Now, my lord, in the meanwhile, there was no speaker. Your lordship knows all this rumpus is about the deputy speaker acting. So on 2nd of July, the election of the speaker is filled on 3rd of July.
Notice election was put.
End of July, the notice for the election.
Now the speaker is fixed for 3rd of July. Your lordship gets these facts in para 26.
Second notice was third election.
Now there are two whips. My lord, one is Mr. Prabhu, who's acting on the Thackeray faction. He says, he issues a whip saying vote for Mr. Rajan Sarvi. And he issues a whip to vote against the confidence motion on 4th of July. In the meanwhile, my lord, Ajay Chowdhury, and this is important, para 28. He is the Thackeray faction appointed leader, issues a letter to the deputy speaker requesting him not to consider the vote cast by the members against whom disqualification is pending. Then, my lord, election of the speaker is held. Now, my lord, all this is academic because the speaker's election is not under challenge before your lordships.
That's also a vision. Which will.
Actually, it all boils down to this, that they didn't face the trust vote, according to you.
Correct, my lord, as far as the first round is concerned.
And the total number of petitions in respect of which disqualification was sought was 16. There was
Correct.
disqualification was square 16.
Now, your
22
lord,
came in later, no notice was issued by the speaker, and then everything was overtaken by the events.
and today you do not have any assertion before your lordship saying, if you take even the 22 plus 16, 38, the election of Eknath Shinde is vitiated. Because by the time he was elected, my lord, after Thackeray resigned, political events then changed. My lord, people who were on one side shifted to the other side.
That's what.
Mr. Salve,
Yes, my lord.
Also show us the prayers in the writ petition.
Yeah, I was immediately going
Has
there.
been filed,
Yes.
has been filed against the decision of the governor on 28th of June 22 to hold the floor test.
Page, Malad, that is writ petition 493. I was immediately going to take your lordship there. This is in the convenience compilation. It's the first writ petition.
Ultimately, what happens is really the two orders, the two judicial orders really seal the fate of the
Correct, Malad.
first order of the 27th,
Yes, Malad.
which says that, we give you time, extend time until the 12th
Yes.
to submit your reply on the ground that the speaker had given only 2 days time. Therefore, the first order says time until the 12th. Then when they came back to the court, challenging the convening of the trust vote on the 30th, our court said no stay. So really speaking, everything, it was these two orders ultimately
And,
which
but
affected
Malad, there's a
first
third.
order had the consequence of
Yeah.
not allowing the speaker to go ahead with the disqualification petitions
Of 16 people.
Before the 12th.
Of only 16 people.
Of 16 people. And the second order had the consequence of ensuring that the trust vote takes place on the 30th.
Correct. Except that
They knew, the Uddhav Thackeray faction knew that without a decision on the disqualification petition, the trust vote was sealed then.
Malad, there also I'm saying the gap was, no Malad, the gap was 16. No, that's not correct. That is not correct because Malad, the disqualification petitions which were deferred by your lordship as 16, they had 58 majority.
I beg your pardon, come again?
The 16 petitions were adjourned.
Right.
The gap was 58 between the BJP and the Agadi.
Yes.
So if you take the 16 out,
That's not the point. Eknath Shinde became the chief minister.
first Mr. Thackeray resigns, then Eknath Shinde becomes chief minister. It's not in the reverse sequence.
So what?
Now, there is no legal, if Mr. Thackeray had contested the election, the effect of which had been in any manner impacted by the non-decision of the defection petitions, some question of law may have arisen.
Yes.
So, my lord, saying put him back means your lordship will then have to declare his resignation illegal. That's the only way he can come back. Now, my lord, let us see what are the petitions before your lordships. Please turn to page 99 of the first petition.
PDF page 10.
He said we are not challenged.
I think Mr. Sibal doesn't realize his mic is on. I can hear everything he's talking to his juniors.
Oh. I'm not saying it. I'm not revealing a state secret.
Not yet.
All in the light of it.
My lord, I was waiting.
Mr. Salve is just cautioning you. 99, is it?
Yes.
99 of the same affidavit, of the same compilation?
Yes, my lord.
Yeah, first.
PDF page 102, perhaps.
493, serial number 1 of the bookmarking of the conveyance.
Two?
Yes, it's bookmark 1.
102.
Is right. It's bookmark 1.
Yes, the bookmark one. You got it, yes.
Yes. And at page 102, because I have 3 page numbers, but I think PDF is 102.
This is writ petition filed against 36. Okay, I get it.
Yes, 30th June. My lord wanted to know the
Yes,
challenge
yes.
to the governor. Pass an appropriate order or direction quashing the decision of the governor to invite respondent 4 to take oath as chief minister. Pass an order declaring illegal proceedings of the Maharashtra Assembly heard on 3rd July. Pass an appropriate writ held on so and so.
Also, election of speaker. Just read that.
Yeah,
Yes, and also challenge the election of the speaker.
Yeah.
Now, my lord, most important is D. And I submit D is, none of this has Nabi. I'm only answering whether your lordship needs to refer Nabi Arabim to 7. Look at D. Call for records of all pending disqualification petitions against so-and-so pending before so-and-so.
This is what I was asking. So that
Three of your lordships will hear these someday and decide whether this extraordinary relief can be given. And whether your lordships can say we will become the election tribunal. The 3 judges or 2 judges of Supreme Court for the first time will try a disqualification petition. But I think it's... So this is, my lord, one petition. This is, I believe, writ petition 393, 493. The second, my lord, is the challenge to the trust vote, which is...
Yes,
this is the interest.
the trust vote challenge.
which is writ petition 470. I think that is number 9 on the bookmark. Page 351. Petitioner whip of Shiv Sena, member of the Legislative Assembly, is constrained to move the court on 29 June, challenging the completely malafide unconstitutional illegal actions of the governor. The governor, by communication of June, which was received as in complete defiance of the fact that the court is seized of the issue of disqualification in a desperate attempt to allow the members who have incurred disqualification a safe passage to hold a floor test on 30th June. His point was that your lordship is considering the validity of the disqualification proceeding.
Question is,
Yes, Mr. Salve.
Yes. Now, my lord, as far as Nabia Rabim is concerned, before I show my lord two more writ petitions, then I'm almost done. It could have applied in two situations. Had there been a trust vote on 30th, and there been an injunction in place, and that I'm assuming that your lordships may have been influenced by Nabia Rabim judgment to give time to 11th of July. Let's assume. The
So
page,
when would have Rabi applied if there was a trust vote actually on the 30th?
and if a court had restrained the speaker from acting, the court only said give time to 11th of July. We are, my lord, today on the 15th of February 2023, the petitions are still pending. And there was a reason why the speaker has done nothing. My friends remind me, because there was a set of cross disqualifications filed against the other group who voted against Eknath Shinde. And they came and complained saying that the new speaker will rush ahead and disqualify. And there was an understanding, keep everything in freeze. Because now there is a speaker, there is no deputy speaker. So obviously these will stand transferred to the speaker unless the speaker's appointment is set aside. So, and they said we have challenged the speaker. So everything is on hold. So Malak, this Nabia Rabim had no role to play in all the events that have transpired. No court had issued a mandamus based on Nabia Rabim, which is an appeal before your lordships. And your lordships have to consider if this judgment was wrong and this mandamus had not issued, then how do we restitute? None of that ever happened. I can understand, my lord, if we had gone to the Bombay High Court following this judgment had stayed the speaker, then the events transpire, appeal comes, your lordship says, no, this Bombay High Court judgment is wrong because we are going to reverse Nabia Rabim. Now how do we restitute? None of that happened. My lord, one thing I will say, when the disqualification law was inserted, there was a clause added originally, which said if you are expelled from the party, you lose your seat. There was a criticism that time, my lord, it was the late Mr. Rajiv Gandhi's government, which had, we know, my lord, had an overwhelming majority. One of the largest ever in parliament. There was a criticism saying, is this a measure that now we have everybody inside the barn, we want to lock the barn door? He dropped that clause. The clause was dropped from the provision when it was finally made, brought into the constitution. Mr. Ashok Sen was law minister that time. So, my lord, this should also, the anti-defection law also, is not a weapon for a leader who has lost faith of his numbers to hang in, because there are layers of political morality in each of these. And my lord, it is best your lordship stay away from all that. Because these are very complex questions. Now, my lord, the second writ petition is bookmark number 9. My lord, Justice Narasimha asked me where is the challenge to the 30th June governor's action. This is that writ petition.
Prayer.
Yes. And in this, my lord, the prayer, I'll give you lordship in a minute, is on page 408.
377, 374, 375 or 377 of the PDF.
Yes, my lord, 377 of PDF.
Challenging the communication of the governor.
That's right. Now, this has clearly become academic because, my lord, on that communication, no meeting was held.
Yeah, I think, look, there should be no trouble. Yeah.
Then we have item 10. Bookmark 10.
It is and it isn't academic, but for the communication of the governor, they wouldn't have resigned.
Maybe, but my lord, if your lordship set aside that communication, what happens?
Ultimately, Uddhav Thackeray, he resigned because of the communication of the governor to hold the trust vote.
Correct. My lord, if he had gone,
He knew that, well, if I have to face the assembly the next day,
yes,
without the disqualification petition being heard, he doesn't have the numbers.
No, my lord, that again is wrong. 16 disqualifications alone were stayed.
Yeah,
11
that's what
July.
you made. 16 plus 22 also you said if you exclude.
38, there's still 58. Secondly, my lord, as a court, political events, your lordship is right. But as a court, if he did not face the trust vote,
what you're saying is that there was never any trust vote, so why challenge the communication?
I mean, it's academic because there was lets the communication goes, what happens? The meeting doesn't go.
It's academic in the legal sense, you're right.
In the legal sense. Correct.
It's all part of one
And
intrinsic.
that's why, my lord, that's why, in my respectful submission, it is hazardous for your lordship to be drawn into.
Right. Anything else, Mr. Salve? Should
Yes.
we
Just want to finish the record.
20 minutes by about 20 minutes.
Yes. My lord, the two more writ petitions remain. I just want to.
Yes, which are they?
My lord, that is, I'll just give your lordships the bookmarks. Item 10, that is challenge to Mr. Gogavle.
479.
But what is important, my lord, and I finish with this, is item 11 by the petitioners.
Item 11.
Yes.
That is Sunil Prabhu.
Relying on Nabiapro. And on which the speaker has held his hand because there was understanding that nothing will be done. And now they are saying this is wrongly decided. Page 412, my lord, your lordship has page 412.
Page?
412.
Yes, and the prayer is at 461.
Yes. No, before that, please just see 414.
414.
Yes. There is a paragraph saying secondly.
It's true because we are saying that no.
Now the petitioners are saying this judgment is wrong. There has to be some rule of holding people to what they have come to court.
It is
Never apply to.
414 you said.
Second.
ये कहाँ है?
Page
411 otherwise.
411.
411 on the right side, Manoj. I believe the PDF page is 411.
That's
This is their petition, right?
Yes. Which relies on Nebi Arabi. Now you can't say this is the law, so on this I'll get a stay, but I'll get up and argue that this law is wrong.
In this petition, in the counter affidavit, did you say that Ibn Rabia is wrong?
No, Manoj. we were careful. except the roles are reversed. Manoj, I will end by...
The bottom line is,
Yeah.
Navam Rebia becomes right or wrong based on, which side you are in which political situation.
Manoj, I will only end by...
Somebody or the other is supporting it. The same people are supporting Navam
Correct,
Rebia.
correct.
The same people
But
oppose
I-
it, depending upon which way.
I've said what I had to say about this, Manoj. This is not a fit case to decide these issues. I will only close, Manoj, with a story which Mr. Parasaran once told us, told the Constitution bench of your Lordship's court, saying in Satyug, a man was a tenant of a farm. He found a pot of gold. He went to the owner and said, "This belongs to you because I only have the farm for cultivating grain." The owner said, "No, God willed you to get it. That is why you discovered it." So they had a dispute. They went to the king, by which time it was Kali Yuga. So contrary to their pleadings, as he explained, the tenant said, "This is mine because I found it." And the owner said, "No, this is in my land, therefore it is mine." So that is what is going on here.
And ultimately, king said it.
Seizes power, gets the pot of gold.
And what the king said is what I want to persuade your lordships to hold. Don't waste my
For
time.
any treasure, we have an act, right? In India, we have an act of 1972, the Treasures Act. When a treasure is found, it belongs to the treasury.
Yeah, it was.
The Constitution.
I was only going to close by saying, your lordship should do what the king did. Tell both of them, don't waste our time. That, Malad, is my submission.
All right. Thank you, Mr. Salve.
Lordship, please.
Thank you.
After Mr. Call, Lord, since I was not here, my Lord, when your Lordships were inquiring who will argue, Lord, I would assist your Lordships, Lord, for 15 to 20 minutes
All right.
with some different angle, my Lord, which I may, Lord, project.
All right.
I'll deal with the merits of the submissions. Now, my submissions, of course, are going to be, my lords, that Nabam Rebia requires no reference to a larger bench. It lays down the correct law. There is no conflict with Kyoto. Nabam Rebia actually considered disqualification of MLAs. It is wrong to say it was only concerned with the powers of the governor. I'll show that. I'll also show how the word freeze in para 191 of Nabam Rebia is read completely out of context. And once that is read with Justice Mishra's judgment, wherein clearly it is said, and in what context it is said, is that under 102, 103 and 191, 192, there are provisions of disqualification either by the speaker or disqualification by virtue of the provisions mentioned in the Constitution in consultation with the governor or the president, as the case may be, and after seeking an opinion of the Election Commission. The freezing word that was used there after referring to Dr. Ambedkar's comments in the Constituent Assembly debates was meant to say that even during those debates, whether it was for the removal of the vice president or otherwise, what was considered of immense importance was the strength of the House on the date that resolution was then moved and not present in voting. So the argument sought to be given to your lordships was that was only in the context of a majority quay, the strength of the House, and how could that be taken to mean freezing the strength on the date the notice is issued? What is not pointed out to your lordships is, and which of course apparent is, that when these Constituent Assembly debates took place, and when these provisions from 179 downwards were all inserted, there was no 10th schedule. And as your lordships have time and again said, that let no provision of the Constitution ever be fossilized. to a stage where any emerging situation or problem is not dealt with. Let it be evolutionary, let it be transformative, and it must deal with the new challenges that emerge. And it was keeping this in mind what the court used the word freeze, and I'll show that in Justice Mishra's judgment as well, was to say that as far as notice is concerned, because that whole debate, that notice followed by resolution, followed by motion are all procedural requirements. My learned friend gave examples. Suppose a notice is given on the last date. Suppose after notice, no resolution is moved. Because these are hypothetical problems, imaginary problems, and constitutional bench judgments are not referred to larger benches on the basis of hypothetical problems that you're imagining. Those are procedural issues. They can always be taken care of. But what your lodges have time and again reiterated and said is that even when a disqualification petition is pending, every MLA has the right to vote, whether it was Shivraj Chauhan, whether it was Bishnoi, whether it was judgments thereafter. So you have had the right to vote. What Nabam Rebia dealt with, that's with the coming of the 10th schedule, the moment a notice is given, the speaker, if he has to act towards unconstitutional ends, will not wait for a motion or a resolution to be moved. He will get into the act right away by disqualifying, and that is what happened here. And the disqualification that they were talking about, the vacancy they were talking about, were only with respect to the powers exercised by the speaker, not with regard to the other disqualification under 191 read with 102, 103, which is purely the domain of the governor or the president, as the case may be, in consultation with the Election Commission of India. They were referring to vacancies, as Dr. Ambedkar said, with the strength being of the then members. So the object and the spirit was take it in totality. It was that totality and composite pool of the then members, of course, minus if someone has died, unfortunately, if someone has been declared an unsolvent, if someone has been declared of unsound mind, and the president and the governor have held them to be disqualified. 191 doesn't say that all of those people will be included. That's a separate provision under 191 and 102 read together. The purpose was that any person who will be disqualified by virtue of the speaker exercising his powers as a tribunal under the 10th schedule must await the decision of the speaker to first prove his own majority, and which Nabam Rebia said is based on both ethical reasoning and constitutional reasoning. The ethical reasoning was that it would be highly improper on your part to go ahead with something and alter a majority and then put your own vote as to the confidence of the House, whereas if you're confident, prove it at the shortest possible time and then take on these petitions. And then they dealt with the debates and said that on the date the notice is issued, you are put to notice on that day that the procedure for motion and resolution will follow. And that is where the mischief may lie. And to curb that mischief on that day, you must stop, the clock must stop ticking on that day as far as disqualification is concerned. Because in para 193 after that, the court goes on to say that if tomorrow a person is wrongly disqualified, he has the remedy by way of judicial review to go and get it corrected. But in the meantime, if a speaker wins his vote of confidence, that is not subject to judicial review. Where will that be corrected? And that MLA would have lost his opportunity to vote. And this is, my lords, given the fact when your lords have time and again in those series of judgments have said, irrespective of at what stage a disqualification is pending, you cannot stop an MP or an MLA from voting. That is the constitutional scheme. And in repeated judgments from Shivraj Chauhan downwards, that is what your lordship have held. So we are dealing today with a situation where Nabam Rebia's para 191 is read and the word freeze is read completely out of context. The Constituent Assembly debates are not seen in their true letter and spirit. And an impression is given to your lordships that Nabam Rebia got it completely wrong. That is the broad perspective of my lords. I'll deal with each of those issues. But please keep in mind, firstly, on which Mr. Salve also briefly addressed your lordships, on what led to these two petitions.
Actually, Mr. Kaul, it's a tough constitutional issue to answer for this reason, that the consequences of both positions have really very serious ramifications for the polity. If you take, if you take the Nabam Rebia position, Nabam Rebia position says that once the speaker is, the existence of the speaker itself comes under a cloud by the issuance of a notice. And Nabam says that then the speaker should not decide upon the disqualification until his own continuance meets the ratification of the House. The consequence of that is then to, as we have seen in Maharashtra, is to allow the free flow of human capital from one political party to another.
So
That's
well
the-
put, Mullah. So
Right.
well put.
So that's one end. On the other hand, now look at the other one. Suppose on the other hand, you say that notwithstanding the fact that the speaker's continuance is placed under cloud by the issuance of a notice, that he can still decide the disqualification notices. The consequence of that then is that essentially, where the leader of a political party has lost his flock or her flock, right? He can still hold them down to his group, though as a matter of real politics, he's lost his flock or her flock. So adopting the other extreme would mean that you are really ensuring a political status quo, though the leader has effectively lost his or her leadership over a group of legislators. That's the other way. If we completely overrule Navam Rebia. If we hold Navam Rebia has also very serious consequences for, because then it's a free flow.
Manoj, I'll deal with that. No, as I develop my arguments, I'll deal with
Ultimately, both ends of the political spectrum are, both ends, whichever way you accept it, has very serious consequences.
Manoj, as I said, let me deal with it. I've just begun, let me deal with it. I like.
The factual scenario.
Both are not desirable in a way that even Mr. Sibal would accept. I mean, we are looking at it as a purely constitutional.
Whereas I'll leave that to when I make the argument on merits. Whereas because I don't want to interfere at this stage. Your Lordship is right at first blush. But whereas the politics of it has not to be decided in the House. I'll demonstrate that. Whereas the politics of defection in the House is not to be decided in the House. You have to go back to the political party, and that argument I'll reserve for the merits, Maharaj. I'm just indicating that to your lordships. Whereas here there is no split in the party. We are talking about a split in the House, which has been rejected under the 10th schedule, because the only way out is merger. This way, Maharaj, you can split any party and form any government, and the human capital will flow, as your lordship said. So the other extreme may not apply in the context of a split in the legislative party. I'm just
Yes.
indicating. And that's the other thing I just want to say.
But
that
both, as I said, Mr.
Yes.
Sibal, both in that.
I will in
Both
response argue
are
that also.
compelling. Both have compelling sides to the.
Yes. The other thing is Eknath Shinde.
Actually, the second one actually.
Says lost the plot, it means in the legislature, not otherwise. This is the issue.
We'll hear it.
And the other thing is, Maharaj, Eknath Shinde was one of the 16, and he has become chief minister. And 164(1)(b) he can't.
Let me in my own way. I'm sure my learned friend will have his chance. Manoj, it's important to know what led to the order of 27th. Mr. Salve touched upon it. In my own way, let me explain to your lordships what led to.
27th came about because a notice of 2 days was given.
Manoj, I'll just, yes, your lordships are right. I'm just adding to it. An overwhelming majority gives a notice on 21st to the deputy speaker for his removal.
For the
Removal of the deputy speaker on 21st of June.
Just one.
Is it 21st or 22nd, Mr.
My lords, that's important. That's why I said 21st of June. That's a very important fact. That's why I'm getting some factual clarity before I come to the legal issues. 21st of June, an email is sent as per the rule, which is rule 18, specifically informing through an advocate a petition signed by 34 MLAs, an overwhelming majority, informing that we have lost the confidence in the deputy speaker. The deputy speaker has filed an affidavit in this court to say that that email was received, but since it was from an unknown address, I did not recognize it. 22nd of June, a hard copy with a stamp with 34 MLAs is again there and provided for. Now on 21st of June, it is important for your lordships to know what had happened. On 21st of June, my lords, a hopeless minority within the Shiv Sena, and that's a progress.
When?
On the same day.
22nd.
21st.
Right.
Because I'm going to address that whole point that this is a defection, it's a split, it is an inter-party dispute is what we've been saying. You have been repeatedly referring to split, clause 3 which has been deleted, defection. That is not our case. And what your lordships and repeated judgments have held, that internal dissent within a party is the essence of democracy. Merely because there is an attempt to change a leader in a political party does not mean it comes within the purview of the 10th schedule and becomes a case for disqualification either under clause 3 as it stood or a case of merger if you don't merge with 2/3. Because we are not talking about leaving the party and merging with any other political party. Our contention right through, and this is what I argued before this honorable court on the earlier 2 hearings, we are the Shiv Sena. There is no question of we represent an overwhelming majority of the party, of the legislature party in this case, and the political party as we claim, which is being decided by the EC. When these people had come before your lordships and said, stay the election commission proceedings. Your lordships have said, how can election commission proceedings be stayed at this stage? That is a powers under the symbols order and the constitution solely given to them. As far as the legislature party is concerned, out of the 54 or 56 MLAs, 40 are here. So when this whole argument which is presented before your lordships, and that is why I said I'll deal with it when the time comes, on free flow, we are not talking about a free flow at all to any other party at all. We are talking about an internal dissent within the political party where an overwhelming majority has said we no longer have faith in Mr. Thackeray, which is an internal dissent within a political party, which every political party is entitled to have and must encourage.
So 21st, you said first that an email by 34 MLAs stating that confidence was lost in the deputy.
Right, and 2 other events, my lords.
On the same day.
On the same day happened. And those 2 events
It was on 24th, not 21st. At least state the facts correctly.
24th.
Email was on 24th, not 21st. You stated it is on the 21st.
My lords, the deputy speaker's affidavit says 21st it has been received.
Email is on record.
It says notice.
Why make a wrong statement?
Just a minute. My lords, his affidavit says on 21st, a notice allegedly signed by 39 MLA was handed over to the office of the deputy speaker. Now, this is the deputy speaker's affidavit.
That's not
and
true.
I'm sure my learned friend will have his chance. Please don't interrupt. All that I'm respectfully submitting, my lords, now is that 3 other events happened on the 21st of June.
Yes.
First is, my lords, a hopeless minority of MLAs.
How many?
Please, my lord.
How many?
24 out of 55 MLAs met and passed a resolution removing Mr. Shinde as leader and appointing Mr. Chaudhary as the leader. This resolution also recognizes that Mr. Prabhu has been appointed as a whip previously. Now, no notice of this meeting is given.
That's 21st again.
21st of June. No notice of this meeting is given. On 21st itself, my lords, the majority within the party of 34 MLAs then, which of course later became about 40, 34 MLAs then reaffirms Mr. Shinde as leader of the Shiv Sena legislature party as appointed on 31st 10 2019. It appoints Mr. Gogawale as the chief whip and cancels the appointment of Mr. Prabhu with immediate effect. So these two events simultaneously happen. Undoubtedly, the majority vote for Mr. Shinde to be retained, that there is no dispute that the 24 were a minority. And on the same date, a notice is sent to the speaker. And on the next date, a hard copy with a stamp is also received on the 22nd in the office of the deputy speaker. So really, my lords, 21 is really for purposes of a complete narration, but even on 22nd, a hard copy had been received.
Page 494, what Mr. Salve was reading.
Yes.
Page 494, just maybe you can just look at that because that gives us a complete picture of what happens in those. That's a crucial period.
Yes, yes, my lord.
Page 494 of convenience compilation.
Yes, yes.
That's, you'll get it at PDF page 497.
Right, my lord, right.
Just have a look at it. You can just quickly run through it. It'll take a minute actually.
Yes. So would your lordships want me to start right from the beginning of 494?
Yeah, the Roman 7.
Roman 7. On 21/6/22, it came to the knowledge of answering respondent and other members of the SSLP that a minority faction of SSLP, that is only 24 of the 55 MLAs, attended an unauthorized meeting and passed a resolution to remove answering respondent as the leader of the SSLP and appointing Ajay Chaudhary as the group leader of SSLP. A true translated copy of the resolution dated 21/6/2022, passed by 24 out of the 55 MLAs illegally removing Mr. Eknath Shinde as leader of the SSLP and appointing Mr. Ajay Chaudhary as leader of the SSLP is annexed herewith and marked as so-and-so. On the same date, that is 21/6/22, 34 MLAs of the SSLP passed a resolution reaffirming that the answering respondent who was appointed as group leader of Shiv Sena legislature party on 31st 10 2019 continues to be the leader of the SSLP. The resolution clearly stated that appointment of Ajay Chaudhary was illegal, void and inoperative. Further, it is the said resolution, Mr. Bharat Gawale was elected and appointed as the chief whip of the SSLP and appointment of Mr. Sunil Prabhu was resolved to be cancelled with immediate effect. A true translated copy of the resolution dated so-and-so reaffirming their answering respondent as leader is annexed herewith. Members of the SLP wrote dated 21/6/22 to the Honorable Deputy Speaker informing him that the majority have reaffirmed the appointment of the answering respondent as the group leader of the Shiv Sena legislature party, therefore not to recognize Mr. Ajay Chaudhary as the leader of the SSLP for the 14th Maharashtra Legislative Assembly. Then 10, thereafter on 21/6/2022, 34 members of Maharashtra Legislative Assembly issued notice under Rule 11 of the Maharashtra Assembly Rules read with 179C, Constitution to the Deputy Speaker so-and-so to move the motion for his removal from the office of the Deputy Speaker and requested him to refrain from discharging functions of Deputy Speaker, Speaker of the Assembly from immediate effect. A true copy of so-and-so of 34 MLAs is annexed herewith. On 24/6, my lords, would your lordships want me to continue?
No, I read that. Yes.
So, my lords, all that I am saying is that when this was done and the notice of removal is given, after that, my lords, what happens is that I am given contrary to the rules. Contrary to the rules which provide for under Rule 18, 7 days time to reply on 2 non-working days, time to reply to the disqualification notice.
That is the 25th, right?
That is on the 25th of June 2022. And 25th and 26th were weekend. And on 27th June.
Now, the notice by the speaker of giving 2 days time was given to how many? 16?
Yes, yes. On 27th June, my lords, again, it's important to know why did we come and what was the order that was passed.
Yes.
May I, my lords? We came by a direct 32 to this honorable court for 3 reasons. Principles of natural justice, my lords, and your lordships in a series of judgments from Algarapuram to Scheller to Balachandar have held that if there is a violation of principles of natural justice, those are one of the rare cases which even the internal proceedings of the House can be interfered with, leave aside an adequate notice not being given for a disqualification notice. So relying on all those notices, we came saying that you give us 2 days instead of the minimum 7 days which the rules provide for. One, those very MLAs, their houses and families were being attacked in Maharashtra. They said, we have no way to even arrive into Maharashtra at the moment. Our lives in our danger, and the only remedy which lies for us is an Article 32 petition. And of course, Nabam Rebia was also referred to, that the assumption of jurisdiction by the Speaker is completely prohibited, because the Speaker, as per from para 188 onwards, the Supreme Court in Nabam Rebia has said that you cannot initiate any proceeding the moment a notice has been given. So we took all the grounds. When the order was passed by the Honorable Supreme Court on 27th of June, the Supreme Court only went by the principle of natural justice and gave more time after hearing the arguments, did not injunct the Speaker from proceeding with the matter. Now, after that, my lords, on the 28th of June 2022, Leader of the opposition, Mr. Fadnavis, went to the governor and requested him to hold a floor test. The governor on 28th of June issued a communication to Mr. Thackeray directing him to face a floor test on the 30th of June 2022. 30th of June. On 29th, my lords, Mr. Prabhu files a writ petition in the Supreme Court saying stay the floor test. And it is at that stage, my lords, that we came before and said a floor test can never be stayed, because your lordships have time and again said that a floor test brooks no delay. A floor test is the litmus of democracy. A floor test is where the dance of democracy takes place, and we will never ever injunct a floor test from taking place. That's the surest way for a set of MPs or MLAs or a government or a chief minister to prove his majority.
Our court declines to.
And the court declines it. Within, it was a late night hearing, by about 9:30 the order is pronounced, and within 10 minutes, Mr. Thackeray resigns. So a chief minister or a leader then, who right through knew he did not have the majority within his own party, had no majority therein, resigns. And as Mr. Salve pointed out, even if those 16 MLAs were removed, even then, if he could, he would have proved his majority on the floor of the House. He doesn't face the floor test at all. So right through this exercise of disqualification, removal of whips, etc., has been carried out by a hopeless set of minority within the party. And one of our principal contentions right through, and that is when your lordships, if your lordships decides to proceed with the matter and not refer it to a larger bench, will be that the whip which was issued, because what was the allegation when they filed the disqualification petition? The disqualification petition was filed against us to say that when we convened those 2 meetings on 21st of June and 22nd of June, you did not were present, and you have thus voluntarily given up your membership of the party, which was one of the grounds under the 10th schedule. Our answer, again, as I said, that's on the merits on a later date, was one, for 21st, you give no notice. For 22nd, you keep it in the same evening at 5 p.m. And thirdly, it is given by a party, the whips are being issued by a party, by a person who has been removed on the 21st by a majority. Mr. Prabhu on 21st of June admittedly has been removed by us, who are the majority within the legislature party. And he could not have issued a whip. So they clearly know they were in a minority in the legislature party. So while they were trying to stall the EC proceedings, they came up with the ingenious argument that no, it's the political party which we looked at, not at the legislative party alone. Your lordships rightly at that stage said, who constitutes the political party is a matter which the EC will decide. Which are the talukas, which are the districts, what is the membership, that will all be seen in the light of Sadiq Ali and all other judgments that will be done. We will not interfere and act as a court of first instance and start deciding what the EC should decide. As far as the speaker is concerned, he deals with the legislature party. He deals with the whip of the legislature party. He deals with the leader of the party. That's what a speaker always deals with in parliament or in the legislative assembly. Now, as far as that legislature party is concerned, you are in a hopeless minority. As on date, 40 are on this side. So this whole, the nomenclature being used repeatedly is to say defection, clause toppling, clause 3 is being defeated, clause 3 no longer exists. That is not the case. The case is we represent the Shiv Sena. We are the majority within the legislature party. So there is no question of any free flow occurring here in this matter. Your lordships are right. There could be a situation. That's not the case here factually. More importantly, my lords, even after that, and this is important for your lordships to know, on 3rd of July, Mr. Rahul Narvekar was appointed as elected as the speaker. At 12:01 p.m. At 12:02 p.m., certain MLAs belonging to the same hopeless minority issued a notice for removal of Mr. Narvekar as the speaker. On 4th of July, 2022, the House reaffirms its confidence in the newly elected speaker. So, my lords, even going by the Nabam Rebia test, this speaker has proven his majority on the floor of the House. The speaker gives notices to both the parties as of those petitions which are pending. Because the matter was before the court, it was agreed between the parties that the matter will not be precipitated. And an argument is made before your lordships that the speaker is biased and he's sitting for 8 months on the petitions.
That's all.
There was an understanding in the court that the matter will not be precipitated any further. Everyone will hold their hands, except the Election Commission, which was never meant to hold their hands, but they kept arguing that the Election Commission was meant to hold their hands. Till we showed to your lordships there was no order injuncting the Election Commission and they were not participating in the proceedings, and your lordships dismissed their injunction application against the Election Commission.
What is the date of notice for removal of the speaker subsequently? 3rd of July or?
3rd July
3rd of July.
at 12:01 p.m.
That's the very day when the speaker was elected.
Yes. So, my lords, after the lordships are right, 3rd is a notice. 4th, he proves his majority. And after that, on 4th, again a confidence motion is moved to remove the speaker. Lordships must know what is being the conduct and who is the party doing what they are doing in the matter, because the impression being given to your lordships is this is murdering democracy. This is leading to horse trading. This is leading to a situation where MLAs are being allowed to defect to another party. Governments are being toppled. But the point which is to be addressed and is not being addressed, that if within your own party there is dissent, and as the leader has lost the confidence of the legislature party, how can that leader ever continue as the chief minister of a state who doesn't even enjoy the bare minimal majority within his own party? Leave aside the confidence of the House. Here was a man who had lost majority within his own party. An overwhelming majority was against him. Leave aside the confidence of the House. And the impression sought to be given to your lordships is as if on that date, had that order of 27th not come, the order of 27th based on Navam Rebia facilitated the toppling of the government, read with the order of 29th, and because of that it fell, and Navam Rebia is wrong law, and thus the matter should be referred to a larger bench. That's the whole impression being given to your lordships. I'm not denying that in my petition under 32, I took Nabam Rebia as a ground. I'm entitled to, my lords, because the Constitution bench has said that you cannot proceed. And if a speaker chooses to proceed, I'm entitled to take it. And I'll tell you, lordships, what the difference between that and Quixote was. They sought to argue this also, then saying that Quixote says no one will come at an interim stage. How could this court on the 27th interfere when Kehoto has said that at the interim stage the court will not interfere? The straight and clear answer to that was, my lords, Kehoto deals with a situation where there is an assumption that the speaker has the jurisdiction. The question is, the speaker is proceeding with something of which he has jurisdiction, and the court should not at the initial stage interfere. We came with a petition where the very assumption of jurisdiction by the speaker was contrary to Nabam Rebia. Now, till Nabam Rebia is referred to a larger bench or set aside, my lords, it's good law. I'm entitled to come and say his very assuming of jurisdiction is contrary to a constitution bench judgment of the Supreme Court. Because the words used in 188 are, he cannot proceed. He cannot even take a step after a notice is issued. That is what the law is. That is why I filed a 32. That is why I raised issues of natural justice and a 32.
Mr. Kaul, that once you invoke Nabam Rebia in your writ under Article 32, it would be putting a gloss on the situation now for you to say that the order of the 27th of June was not based on Nabam Rebia, was based only on the ground that there was a violation of the principles of natural.
My lords, may I with respect?
In fairness, the order doesn't say what the basis of the order is, but you invoke the jurisdiction of the court.
My lords, I cannot make
you are entitled to it.
I cannot make an incorrect statement that I did argue it in the petition.
That's right.
I'm not for a minute even suggesting that I did not argue it during oral hearings. I did. But the fact remains is, my lords, I'm still entitled to say that ultimately, my lords, your lordships has said the order is what it says. The order of the court clearly only goes on one premise.
There is no restraint on the speaker.
My lords, if Nabam Rebia was relied on, then there would have been a restraint on the speaker. Otherwise, Nabam Rebia has no meaning at all. Nabam Rebia does not talk about 2 days extra being given or 5 days extra being given. That is not Nabam Rebia. That is your lordship's entire line of judgments in Algapuram, Scheller and Balachandar. Those are that if natural justice is violated, in any case.
Equally, the order doesn't say that you file your reply on the 2nd of July.
Yes.
The order says you will not file your reply. You will have time until the 12th.
Yes. So, my lords, all the time.
If it was only an order based on natural justice, it would have said, all right, the speaker will not pass any order before the 2nd of July.
My lords, may I with respect
Didn't say that. So obviously the reason was you had also invoked Nabam Rebia, and you, as you fairly say, that was your case. That was your case. You are entitled to it.
My lords, I may be wrong, but as I read the order, as I see it, the court said we are giving more time to file a reply. And that is where the order ended. Till this order does not injunct the speaker in some way with either proceeding or passing an order, according to me, Nabam Rebia, I think in all humility, I am entitled to say, was not the basis of the order passed on 27th of June, for the simple reason that the natural consequence of Nabam Rebia or reliance on Nabam Rebia will be that the speaker will not proceed with the matter. I said, Nabam Rebia is not on any other issue at all. Nabam Rebia is not on natural justice. Nabam Rebia is only on the fact that should the proceedings under 179 and 10th schedule are concerned, if there is a notice under 179, then the 10th schedule exercise of jurisdiction is brought to a standstill till 179 is decided. Is all that Nabam Rebia is about.
Eventually, Mr. Kaul, on facts, your case is very clear. Your case is, look, once the trust vote was called by the governor, you moved the Supreme Court. You means they moved the Supreme Court, seeking a stay on the trust vote. 29th, our court says, no, there will be no stay on the floor test in the House. Rightly so, because there can't be a stay on floor test. That's the ultimate litmus test, as we have always said. Thereafter, the only course of action for them was that, well, face the House and then decide how much of the vote is ultimately influenced by the presence of the persons who were sought to be disqualified. They obviated that by resigning. They never faced the House.
I could not have put it better, and why I'm emphasizing.
That is really the point which we will have to deal with.
Why I'm emphasizing on this is
because ultimately you don't face the House at all. That is something we will hear.
Why I'm emphasizing, and my lords, I'll also deal with Nabam Rebia and show some of those judgments and the provisions and Constituent Assembly debates. I'll just come to it. The reason I'm emphasizing on this is, my lords, because this whole impression is given that it is because of this order that defection, toppling of governments, things against constitutional morality happened. That's completely wrong.
The process had process had commenced probably on the 21st itself.
Right.
It's obvious from the meetings which were being held by both the factions.
Right. And my lords, it is no one's case that when the resolutions were adopted on 21st, 22nd, undoubtedly has a majority of MLAs within the party. They now try to get out of it by saying, no, let's look at the larger political party, not the legislature party, which in any case, the lords has said is for the EC to decide. And we'll get into those issues at a much later date because those are complex issues. Which taluka, which district member, how many members, that's a separate issue.
Mr. Kolby, I think we've got the hang of the facts now. The facts have been...
So, my lords, let me now go on to...
Go directly to Nabam.
Nabam, and my lords, I'll cite Nabam in a few other judgments and make good my submission, my lords. Yes.
We'd also like to hear you on whether a reference to Nabam is a live matter in this case. There is something which we would like to, because that's an area which we are open. You can argue it at two levels. First, you are entitled to argue that don't refer Nabam in this case. And two, that Nabam, in any case, according to you, lays down the correct position in law.
So don't refer.
Sorry. So don't refer.
So don't refer, and it's no longer a live matter.
The second point
is what your lordships are saying.
Yeah.
That was
correct.
Once you say that it is correct, there's no question of...
Yes. Very well.
I think your point that Nabam, the reference doesn't arise, you have already dealt with in your statement of facts, because that's why you've highlighted the fact.
Not only that, my lords, I want to show to your lordships, because it fell from my lord, the Chief Justice, in the proceedings. It's free flow. I want to dispel that impression and show what was Nabam all about. Under what circumstances Nabam was. What were the Constituent Assembly debates?
No.
At length arguments were addressed on that. And that is why
that is to be decided in a disqualification.
as Nabam is concerned, now I'll just come to the relevant paragraphs and I'll read a few paragraphs from the majority decision and also Justice Mishra's separate opinion on the matter. Now, the point was this. The word freezing did not mean that whatever is the then strength, irrespective of disqualification under 102(1) or 191(1), or a member is dead, is frozen. It has to be read contextually. Justice Mishra deals with it and says that, look, the approach we are adopting, that the powers exercised by the Speaker under the 10th schedule should, in the meantime, he should hold back till 179 is decided, is in consonance with the provisions under the Constitution which exist, which are, and he relies on Article 181 and Article 189 to say, let's see a scenario in 181 where he can vote on a resolution against his removal. But if it's a tiebreaker, he cannot vote because he.
Justice Mishra puts it really on this ground that when the Speaker exercises the power in qualification under the 10th schedule, I think he has to act impartially. It's in the nature of a judicial function.
Absolutely.
Therefore, anything which is liable to affect your credibility in the discharge of a judicial function must therefore govern when he
I bow down.
when his own authority to act as a speaker is called into.
I bow down.
The logic.
But he adds a very important argument also to it by saying that the provisions of the Constitution as they stand indicate and support exactly what we are saying, and that was in the mind of the framers, because 181 entitles a speaker to vote in a resolution against him, but not in a tiebreaker. Because in a tiebreaker, then he would be a judge in his own cause. But under 189, he cannot vote except in a tiebreaker. So Justice Mishra draws that distinction and says even the provisions as they exist before the 10th schedule was introduced did indicate that the speaker in these matters must reflect a position of complete impartiality and avoid any form of conflict of interest. I'll read those paras to you, Lord.
Just those 2 or 3 paras, let's if you,
yes, and my lords,
why don't we look at the provisions
and,
of the
and just
Constitution?
one
Go to those 3 or 4 paras, that will really cut short everything.
Yes, and then my lords,
It's the heart of the matter.
yes, and then one more thing, my lords, before I come to Nabam Rebia, just one more thing. Nabam Rebia also discusses the fact, and Justice Mishra discusses it, that all the provisions that you're now referring to were framed and adopted at a time when there was no 10th schedule.
Yes.
If 10th schedule was in place, and I'll rely on some judgments to say that no provision of the Constitution ever should be fossilized if there are changing circumstances, emerging problems. Your lordships will take an evolutionary interpretation to deal with that problem. The problems that are being placed before your lordships to say Nabam Rebia are wrong are completely procedural. To say on the last day of the session, a notice is given, then there is nothing for 6 months, or a notice is given but no resolution is moved. These are hypothetical problems that you're thinking of that can't be the basis of Nabam Rebia being referred, my lords. I'll show rules which do provide for an expediency, which do provide for an expeditious disposal. B, those checks and balances your lordships can always consider if there is a scope after a notice of misuse. But there is a difference between saying that after a notice is issued, there could be a scope for misuse by a resolution not being moved, or a notice being issued on the last day, and to say that the law laid down by Nabam Rebia is not correct. Those procedural misuse, if at all, today these are just imaginary misuses which may occur, could occur, can't be the basis, according to me, for a 5 judges decision being referred to a larger bench. B, if that were to be so, your lordships in an appropriate case can deal with it. That you can't hang on to it and not decide the matter indefinitely, especially when the rules itself provide for 7 days notice, decision as early as possible. Those indications are there in the matter. But what you're seeking to say is that right in the meantime, there can be no hiatus. There was great emphasis laid on the word there was no hiatus in a constitutional functionary. Now that constitutional functionary who assumes jurisdiction under 10th schedule, 2 dangers lie. One, and the arguments ought to be made before your lordships were, that 179 and 10th schedule are separate, and thus one cannot be interfered with the other. There are 2 dangers with that argument. One, the very continuation of the speaker under the 10th schedule and assuming jurisdiction as a tribunal is dependence on his legitimacy to continue, which is being decided in a 179. Secondly, the danger, the moment a notice is issued to the speaker, and your lordships have time again from Kyoto to Nabam Rebia said, that these are realities of the time. Speakers are also political appointments. These are words of the Supreme Court used, and we can't ignore the fact that there may be a scope for misuse in these matters. That speaker who has to misuse or work towards an unconstitutional end will not wait till the date a resolution is moved or a motion is moved in terms of 179 read with Rule 11. He'll start acting as of yesterday on the date the notice is issued. And if in the process he disqualifies all the MLAs whom he feels will be inconvenient to his interests, the entire pool changes. And that is where Dr. Ambedkar, when he referred to the then 10 members of the House, said that you can't restrict it to the majority of present and voting. It should be majority of the then members. What was the reason behind it? The reason behind it was that the strength of the House should be reflected. Now, naturally, the argument in 191 can't be that by using the word freeze and the then members and strength of the House, Nabam Rebia has ignored that so many people may die, may be disqualified for other reasons. That's not what Nabam Rebia says. It only says that 191 subclause 2, 191 and 102, my lords, consciously make a difference between disqualification, as I had respectfully submitted, on grounds mentioned with the governor or the president taking the decision in consultation with EC, and 2, referring to the Lok Sabha, to the 10th schedule and the speaker of the Lok Sabha.
Mr. Kaul, why don't we do this? Why don't we look at the we'll allow you to sort of create a theory based on the bare text of the provision.
Yes, yes.
You go to Nabam and
Yes.
Let's look at the provisions first.
So, my lords, let's look.
We look at it independent of Nabam, and then see whether Nabam is correct or otherwise.
Yes.
Because let us first look at it as a
So, my lords, what I'll attempt to do is I will just show to your lordships 191, 192.
Yes.
Paramateria is 102, 103 for the parliament. Then I'll show 181, 189. And I'll straight away thereafter come to the paragraphs of Nabam Rebia.
That will be logical then.
On this aspect, my lords, before I...
You can read it holistically, taking within its sweep even 10 schedules.
Yes, yes, my lords. So please have, my lords, I'll start with 191 since we are dealing with an assembly instead of 102, 103. Please have 191.
Because we read it as a
a person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state, A, if he holds any office of profit under the Government of India or the Government of any state specified in the first schedule other than an office declared by the legislature of the state by law not to disqualify its holder, B, if he is of unsound mind and stands so declared by a competent court, C, if he is an undischarged insolvent, D, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state or is under any acknowledgement of allegiance or adherence to a foreign state. E, if he is so disqualified under any law made by Parliament. Explanation: for the purposes of this clause, a person shall not be deemed to hold the office of profit under the Government of India or the Government of any state specified in the first schedule by reason only that he is a minister, either of union or of such state. 2, a person shall be disqualified for being a member of the Legislative Assembly or Council if he is so disqualified under the 10th schedule. So 10th schedule, my lords, firstly is a separate provision altogether. Then 192. If any question arises as to whether a member of a house of the legislature of a state has to become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to the decision of the governor and his decision shall be final. Before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinions. Yes. Now, my lords, please have, this, my lords, was for the proposition that when the word freeze, the then members are considered, and the argument sought to be made is Nabam has got it completely wrong, because a person could have died, a person could have been disqualified for other reasons, etc. Everything is frozen on that date. That's not the context. The context of the word freeze is that anyone who can be disqualified by the speaker under the 10th schedule will not be disqualified, and the then members of the House or the composition of the pool of the House at that stage will be dehorse the exercise of power under the 10th schedule.
Now, which is the next provision you want us to see?
Yes, my lords. The next provision is 181. Is the provision? This goes to 2. My lords has 181. Article 181.
Yes.
The speaker or the deputy speaker not to preside while a resolution for his removal from the office is under consideration. At any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and the provisions of clause 2 of Article 179 shall apply in relation to every such sitting.
Start with
Let's see 179.
Yes, ma'am. I'll start with 170. I'm sorry, my lord, I should have started with 170. Vacation and resignation of and removal from the office of the speaker and deputy speaker. A member holding office as speaker or deputy speaker of an assembly, A, shall vacate his office if he ceases to be a member of the assembly. B, may at any time by writing under his hand address, if such member is the speaker, to the deputy speaker, and if such member is the deputy speaker to the speaker, resign his office. And C, may be removed from his office by a resolution of the assembly passed by a majority of all the then members of the assembly, provided that no resolution for the purposes of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Provided further, whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the dissolution. And now, my lords, may I read 181 again, Your Lordships?
Yes.
The speaker or the deputy speaker not to preside while a resolution for his removal from office is under consideration at any sitting of the Legislative Assembly, while any resolution for the removal of the speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and provisions of clause 2 of Article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the speaker, or as the case may be, deputy speaker is absent. The speaker shall have the right to speak in and otherwise take part in the proceeding of the Legislative Assembly, while any resolution for his removal from the House is under consideration in the Assembly, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or any other matter during such proceeding, but not in the case of an equality of votes. Now read this, my lords, with 189. Article 189, my lords. My lords have 189?
Yes.
My lord, the Chief Justice.
Yes.
Voting in houses, power of houses to act notwithstanding vacancies and quorum, save as otherwise provided in this constitution, all questions at any sitting of a house of the legislature of a state shall be determined by a majority of the votes of the members present in voting, other than the speaker or chairman or person acting as such. The speaker or chairman or person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. So, my lord, Justice Mishra relies on it to say that these provisions also are an indicator of the constitutional trust, avoidance of conflict of interest, and any decision which directly impacts him. 181, where there is a tie, he cannot vote. In other cases, he cannot vote, but if there's a tie, he can vote. And he said these are all indications, and it's the same principle that we are adopting. When under the 10th schedule, where he is to decide on the people who may tomorrow vote against him under 179. And if he takes a decision to consciously disqualify them between the date of the notice and the resolution under 179, he would have altered the pool.
181 flips the
Yes.
So 181 says you can speak and vote, but not in the case of an equality. 189 says that the speaker can vote only when there is
of a tie. Yes.
So the normal rule is that the speaker can exercise the right to vote when there is a tie, but where the vote is on whether he or she should be removed, then he can't
Right.
exercise his-
And that is what Justice Mishra relies on to say as one of the grounds that he derives his strength and support from. Apart from the larger picture of constitutional trust and conflict of interest, those are the provisions that he relies on to come to the conclusion that he does in the matter. So that impartiality of the highest standards is maintained. And conflict of interest in any form, even the remotest, in I'm giving this is actually a problem. And that is exactly what unfolded in this matter. That the moment a notice is given for removal, you start diluting or altering the composition of a pool of people who will vote for you or against you under Article 179 of the Constitution. So if you've already succeeded in what you were to do, will be a fait accompli.
If you look at it purely in a literal, we've never interpreted the Constitution just literally. It's an organic document. But if you interpret Article 181 in a very literal sense, it places only one disability on a speaker. That disability on a speaker is that once a motion for the removal of the speaker is under consideration, the speaker shall not preside on the motion where his removal is under consideration. But while he cannot preside, he can participate and vote, but not exercise a casting vote.
Right.
Now, 181 therefore seems to indicate that the mere fact, we'll now read whether that is affected by the 10th schedule, how the 10th schedule affects it. Because 181 was brought in before the 10th schedule came in.
Right.
191 was amended to bring in 191 too because of the 10th schedule.
Right.
181 seems to suggest that save and except for this disability on a speaker who is facing a motion for removal, namely that you shall not preside you are entitled to speak and vote, but you will not cast a casting vote. Save and except for this disability which is cast under 181, the Constitution places no.
His own removal is concerned. That section, that article only deals with his removal.
Therefore, that now we are imposing, as Justice Mishra also imposed an implied limitation on the power of the speaker. Now, he develops that implied limitation on the basis of the 10th schedule. Because there's nothing in Article 181. 181,
Yes, my lord, absolutely.
Justice Keher reads that in, which Justice Mishra also in passing refers to by the use of the expression the then members of the assembly.
Right.
And that is probably the weakest link in the argument.
Presiding restrictions are.
Mr. Paul, if we can read a principle, into 189.2, right? And into 181.1. If we can read, what is the constitutional principle? The constitutional principle is a principle of constitutional bias. Namely, that when a motion for your removal is under consideration, you shall not preside as a speaker, right? Because if you preside, then you will channelize the debate, you will channelize the conversation, the dialogue in Parliament, in the state legislative assembly. So it incorporates the principle, the rule against bias.
Rule against bias.
So 181 is a constitutional incorporation of the rule against bias. But it also incorporates the principles of natural justice by saying that, look, you can certainly speak, but it dilutes a little bit of the principle of natural justice by saying you can also vote on a motion for your own removal. Normally, you can't vote on a motion for your own removal. It allows him to vote on a motion for his own removal, subject to the caveat that the casting vote which is given to you in your capacity as a speaker, you will not vote. You will not wield on that occasion.
Right. So, my lord,
So it's a very delicate, it's a very beautifully formulated principle.
but delicately balanced.
No, it
keeping
takes
in mind-
care of all aspects of the matter.
Right.
It takes care of the bias part of it, which is an institutional principle. At the same time, it takes care of the individual right of the speaker also, giving him an opportunity to speak.
Now what Nabam does is, by sourcing these, though it doesn't say so in, Justice Mishra hints at it, by sourcing these principles in 181.2, what Nabam does it extends it a little bit by saying that if the vote on your removal as a speaker is liable to be affected by the exercise of your power under the 10th schedule, then you can certainly affect affect the outcome of a motion for your own removal by exercising or not exercising your powers under the 10th schedule. So therefore, don't exercise your powers under the 10th schedule so long as the vote for your own removal is not is really fluid.
But the real question is that when does that obligation commence upon the speaker? That is on the basis of the notice or prior in point of time. At what time it comes? That becomes very crucial. Even if we take this interpretation.
Mr. Paul, you have to make submission on under consideration.
Under consideration.
At what stage it can be said to be under consideration? Huh? Taking up the that can be said to be taking under consideration.
Correct.
Now, my lords, may I address it?
See, the 170, the proviso to 179 says 14 days notice has to be given. That's right. Of the intention to move the resolution. Does the prohibition attach the moment an intention to move a resolution is given within the meaning of the proviso to 179? Or does the prohibition attach when the motion is under consideration within the meaning of 181.2? And then, how do you, as Brother Shah said, what is under consideration? Does under consideration begin even when the notice for moving the resolution is given under 171, under the proviso to 179? Or does it become under consideration only when the House has a motion for debate? You can reflect on it at lunch. We'll come back at.
Malad, I just want to say, Malad, a lot of arguments have been made on facts, Malad, which I not.
But now this is, we are not.
I hope, Malad, that because all the facts that my learned friend mentioned, Salve mentioned.
Rebutting on what arguments
No.
I
never made any arguments.
I think you made a sizable argument.
Facts we are good to where, because Malad, a lot of these facts have been misrepresented and against the record. So I don't want to go into that, Malad. I mean, we are talking of only on the issue.
It's not getting into it. It's got substantial arguments on facts. Grateful.
The screen, this is unmuted. Check my chat. Looks like we have time.
भैया हाँ तेज दो I told my yes.
Floods, before I come to Nawab, before lunch, when your lodges rose, what your lodges had observed was that under Article 181, a fine and delicate constitutional balance is maintained by the framers of the Constitution. So on one hand, you will not preside, you will not vote in a tie. You could vote on any matter connected with the removal, but not in a tie, and you will not preside so that you don't channelize, as my Lord the Chief Justice said, a debate in a particular direction. That's the fine balance in this case. But please keep in mind that this balance under Article 181 is one in a scenario where the entire House is involved. The Speaker is not all in all. The entire House is involved. Even there, quite contrary to 189, they say in a tie you will not vote. Under the 10th schedule, when the Speaker acts as an adjudicatory body, deals with an issue as a tribunal, he is the all in all in that situation. So how will a fine constitutional balance dealing with a scenario under 10 be maintained? And that is my respectful submission that if, as the words as used by my lords, that if constitutional violence and bias are to be avoided, as it is avoided in under 181, is to be avoided under the 10th schedule. The date has to be the date of the notice. And that is another thing directly dealt by Justice Mishra in his judgment, saying that those days between the date the notice is issued and the 14 days to move a resolution, the entire composition could be changed of anyone who is inconvenient and what happens thereafter. Whereas in the case of an MLA who is then later disqualified, he can come and get it rectified as far as judicial review is concerned. But what happens that he misses that opportunity to vote? There is no judicial review of a removal. And what is also important is there is no vested right to continue as a speaker. If you are removed as a speaker and you win the confidence of the House again in a scenario, you can be re-elected as a speaker. You don't lose your membership of the House. Whereas as a member of the House, if you are disqualified unfairly by the speaker who wants to alter the pool so that he can win his election under, he can defeat a resolution for his removal under 179, the bedrock of democracy is shaken, because not only do you lose your right to vote in parliament, there is a whole constituency which goes unrepresented. So we are talking about a much greater harm even if we are balancing the two. You're dealing with a person, a constituency going unrepresented, an elected representative losing his right to vote, which shakes the very bedrock. A speaker can always get re-elected if he has and he doesn't lose the membership of the House. So all that I am respectfully submitting, my lords, is that the potential harm of the constituency being left unrepresented and a government which is not enjoying the support of the members being established, because if you've removed half the members who are inconvenient to you, something far more dangerous and damaging to democracy can happen. And that is why in para 191, Nabam Rebia says that if he establishes his confidence, wins the vote of confidence, then he goes on to decide. And as far as the members are concerned, if they are unfairly disqualified thereafter, the court can set us aside. But you can't avoid your resolution for being removed by first disqualifying the members. It is in that context. So 181, when it maintains a fine, delicate balance, it is not dealing with the 10th schedule scenario at all. Now in 10th schedule, my lords, I take it. Suppose as it's being argued, it should be at the date of motion or it should be date of resolution. That's being argued that if at all someone has to hold their hands, it should be at that stage. Now, my lords, these are all matters of procedure. 14 days notice, resolution, motion under the rules, whatever you may call it. But the speaker who intends to change the composition of the then members of the House will not wait till that stage.
What is the point of time at which the disability on the speaker?
My respectful submission is, and that is what I am now coming to Nabam Rebia, is on the date of the notice under 179 subclause C proviso. When that notice is issued under 179 subclause C proviso, is when the disability comes in. Because as Justice Mishra deals with it, that the moment you express your intention to remove a speaker, he can start acting. He doesn't have to wait till the resolution is moved. Till the motion is moved.
But that will have very serious ramifications for the reason that a person who moves the motion, you require only one person to move the motion.
Right.
There's no threshold required. Second, the person who moves the motion, who moves the notice, who issues the notice may not move the motion at all.
So
this would be capable of grave misuse. That is, to prevent the speaker from exercising any power. You have to only say any power to decide the disqualification. You have to only get one person to issue a notice to the speaker that I'm asking for your removal.
Well, you see.
It's like a beat.
Does it lack?
We will get a better picture if we see the constitutional provision along.
See the rules now.
Rules show us in the context of rules.
States and on the strength of one notice.
So I was just answering that. I had addressed your lordships today in the morning and on that. These are what are examples being given that someone moves a notice, does not move thereafter. Or someone gives a notice on the last day of the session, when the session ends and 6 months later. My lords, these are situations of procedure or a possible misuse of procedure which can be corrected by interpretation. But to say that because of this, Nabam Rebia is bad law, is what is wrong. These are issues after all, and I show rules. There are rules within the...
According to Nabam, the disability gets on the speaker.
Yes, but my lords, what I am saying is,
the notice is...
I'll show I'll show that if the danger is a misuse of a procedural irregularity or a procedure being misused of notice to the period of resolution being moved, even the rules say as soon as possible, within 7, I'll show those rules as they come forward.
Let's see the rules now.
Yes. Manoj, can I do one thing? Can I just go through Nabam so that we at least have that, and then I'll move on to the rules.
All right.
You'll get a better understanding if you see the rule first.
Because, we have seen the constitution. Now let's see the rules.
We'll independently
So that
consider
then
the
we
rule
can
and then
independently look at
see
the
judgment.
interpretation and then see Nabam.
Page 40 of
So Nabam is at 973, volume 1.
Yes. Manoj, can I start with that, Manoj, and then come to the rules?
I feel that's better. No, let's go to the rules, I think.
Very, as you know. Can I first take your lordship through Rule 11?
Where are the rules?
that's the first document.
3C, no?
Compilation, yes.
Compilation of rules and judgments, 3C.
PDF page 42.
Page 40.
Page 40. First index, page 40.
My lords, PDF,
Page 25.
42.
page 25, Rule 11, compilation 3C,
42.
25, volume 3C, volume 3C.
Volume? Which volume?
All the statute compilation is at, it's at PDF 42. What grade?
That's correct. That's full.
A lady that doesn't have the full rule, so this one I
Okay, you have redone it. Okay, all right.
compilations and judgment.
He's not in first of the fact.
The compilation of rules.
3C में 11 है, ठीक है? Same thing.
PDF?
What is that?
24.
2025.
Rule 11. 3C.
Yes.
You could get imagine here.
25.
Yes, we have.
And that's why the court mark. Chetan, motion. Rule 11.
My lords, have Rule 11. A motion to remove the speaker from office of which 14 days notice as required under Article 179 of the Constitution has been given shall, as soon as may be, after the expiry of the notice period, be read to the Assembly Speaker, who shall then request the member who are in favor of leave being granted to move the motion to rise in their seats, and if not less than 29 members rise accordingly, the Speaker shall intimate that leave is granted, and then the motion will be taken on such day, not being more than 7 days from the day on which leave is granted, as he may appoint. If less than 29 members rise, the Speaker shall inform the member who may have given the notice that he has not the leave of the Assembly to move it. So, my lords, one is that 14 days notice as required, so shall be given as soon as may be. I'm just on the indications within the rules. As soon as may be, and then it says not being more than 7 days, both on an expeditious disposal. Now kindly have 18. My lords, have Rule 18.
It says on the receipt of the 14-day notice,
So there are 4.
as soon as may be after the expiry of the notice.
Yes.
So therefore,
14 days has to be, my lords, because that's what the Constitution provides for.
14 days notice must expire. And then the members who have made the request.
As soon as may be after the
Should
expiry,
leave
be read to the Assembly of the Speaker, who shall then request members who are in favor of leave being granted to move the motion to rise in their seats, and if not less than 29 members rise accordingly, the speaker shall intimate the leave is granted and that the motion will be taken on such day, not being more than 7 days from the day on which the leave is granted. Read it in totality, my lords, with Rule 18 and Rule 20. And the scheme adequately of the rules provides that these whole thing that you give a notice and you forget about it, nothing happens after that, then someone sits on it and there's a hiatus and the speaker can do nothing after that. And if at all such a situation were to arise in some case, my lords, it could be dealt with, because that is what your lordships, all these judgments on transformative interpretation, evolutionary interpretation are. Today, the point is not that. The point is, can a speaker, while his removal is pending under 179, alter a pool? That's all that Nabam Rebia decides. Can you alter the pool while you yourself are the only authority which decides on disqualification, and you can use that power as a tribunal to completely influence the decision as far as your removal is concerned? If that whole pool of removal under 179 changes, 181 fine delicate balances where the whole house is involved.
No, but therefore, according to you, the moment even one member gives the notice, the stay on the speaker attached.
All I'm trying to say is that it won't be indefinite, because the rules provide that resolution should be brought and put to vote. So it's not something
Speaker doesn't do that.
Please, my lords. Taken up under 181. Secondly, as I am respectfully submitting, my lords, please see the word, a motion to the speaker as soon as may be, has to take it up. To answer what my lord said, if a speaker doesn't take it up, then a speaker is the person who's the interested party. Then Nabam Rebia, in any case which we feel is the correct law.
Because it is against him.
Yes, yes. So this whole imaginary problems to say there has been no legal answer. They've given things which have not arisen, which have not happened. And that is why I have respectfully submitted, my lords, what is the legal constitutional infirmity in what Nabam Rebia has said, which is that a person whose own removal is to be decided cannot in the meantime exercise a power under another provision of the constitution to alter the set of people who will vote against him or vote in his favor, or alter it to his benefit. Now please see, my lords, Rule 18.
There shouldn't be disqualified.
My lords, has Rule 18. Every notice required by the rule shall be given in writing addressed to the secretary and shall be left to the assembly office, which shall be open for this purpose on every day except Sunday or a public holiday, so and so hours. This period of every notice shall be counted from the day on which it is received, provided notices shall be received and the office is closed, shall be treated as having been received. A copy of every motion other than resolution which notice is received shall be sent to each member after it is admitted by the speaker. And then kindly see 20. And please see 20. On the prorogation of a session, all pending notices shall lapse except those in respect of unstarred questions. No day yet named motions, statutory motions, amendment rules, motions of consideration of which have been adjourned to the next session under Rule 37, bills which have been introduced and amendments to such bills shall be carried over to the list of business for the next session from the stage reached by them in the expiring session. My respectful submission is twofold, that once the notice is received, it has to be put. We've not come across a case where a notice is given and no one has done anything after that. That is not the case here. The case is not here that on the last date a notice has been moved and we are waiting. In appropriate cases, even a special session could be called if removal of the speaker is the issue. But the question today is that can that be the basis of determining when can the speaker or when the speaker should resist and desist from altering the pool. That's the limited question on Navam Rebia. And naturally, as Justice Mishra and Navam Rebia says, the moment you express your intention to remove a speaker, that's when he starts acting. He'll utilize those 14 days before a resolution is to be moved, or a motion, call it what you may. Resolution, motion, whatever, he'll utilize those days. Justice Mishra directly deals with this issue. And I'll come to it, and there's a reason. He says because there was no 10th schedule when these articles came. So the fine, delicate balance in 181 is to be seen in the context of minus 10th schedule.
But equally, you must also postulate that, look, after the 10th schedule, some of the substantive provisions of the Constitution were also amended. So 191(2) came in by the same 50th Amendment, which brought in the 10th schedule.
Right.
But Parliament didn't make any amendment to 181.
Right. But my lords, as I respectfully submit, but if a challenge arises, if a problem arises, that's where your lordships have used your lordships' rules of interpretation and interpreted provisions to say that constitutional interpretation is flexible to ever-changing situations and problems that arise from time to time. Your lordships have time and again said, if Parliament had taken care of every constitutional situation which may arise, then your lordships' judgments to say that in appropriate cases, your lordships may have to adopt evolutionary and transformative tools of interpretation to meet ever-changing situations would not arise, then Parliament would take care of every situation. But your lordships have utilized those tools, and that is why Nabam Rebia utilized those tools to come to the conclusion.
Any other rule now? Any other rule?
These are the principal three rules.
Now let's go to Nabam.
Yes, now let's go to, yes.
973.
Yes, sir. Give me a minute. Just give me a minute. Para 188.
1145.
1145 PDF page. My lords have.
You showed us rule, sorry for interruption. Rule 11, rule 18, and which of the?
20.
20. 50, yeah. 20. Yeah.
What fell from my lords, if as rule 18, for instance, says the speaker will admit on a notice being given. Look at the other scenario. You give a notice and the speaker doesn't admit it. Like he started in this case by saying it's from unknown people. An advocate's notice that's signed by 34 MLAs. And he's saying it's from an unknown source. So it's for his own removal. And he doesn't want to go through with the motion. What happens then? He ultimately has to admit it. May I read?
Yes.
Yes. The issue canvassed and answered here para 188. The issue canvassed and answered here and above with reference to the 10th schedule does not fully answer the controversy which has arisen propriety of the Speaker in conducting proceedings under 10th schedule, when his own position as Speaker of the Legislative Assembly is under challenge. After all, this was the real basis of the Governor having passed the impugned order and message dated 9/12/2015. The challenge to the Speaker's position in the instant case was based on the notice of resolution for his removal dated 19/11/2015. The resolution was moved by 13 MLAs, 11 belonging to the BJP and 2 independent MLAs. Despite the above, unmindful of the challenge raised in his own position, the Speaker went on with the disqualification proceedings initiated by the Chief Whip of the Congress Legislature Party on 7/12/2015 by issuing notice to them on 7/12/2015 itself, seeking their response by 14/12/2015. All the 14 MLAs aforementioned were disqualified by an order passed by the Speaker on 15/12/2015 under the 10th schedule. Was this action of the Speaker justified? The Learned Counsel for the rival parties pointedly addressed us on this issue. We are also of the view that this issue needs to be determined in view of the direction which will eventually emerge on the basis of consideration recorded here and above. A repeat performance of the earlier process would bring the parties back to the threshold of this court for redressal of the same dispute which is already before us. When the position of a Speaker is under challenge, through a notice of resolution for his removal, it would seem just and appropriate that the Speaker first demonstrates his right to continue as such by winning the support of the majority in the state legislature. The action of the Speaker in continuing with one or more disqualification petitions under the 10th schedule, while a notice of resolution for his own removal from the office of the Speaker is pending, would appear to be unfair. If a Speaker truly and rightfully enjoys support of the majority of the MLAs, there would be no difficulty whatsoever to demonstrate the confidence which the members of the state legislature repose in him. The office of the Speaker, with which the Constitution vests the authority to deal with disqualification petitions against MLAs, must surely be a Speaker who enjoys confidence of the Assembly. After all, disposal of the motion under Article 179C would take no time at all. As soon as the motion is moved on the floor of the House, the decision thereon will emerge forthwith. Why should a Speaker who is confident of his majority fear a floor test? After his position as the Speaker is affirmed, he would assuredly and with conviction deal with the disqualification petitions under the 10th schedule. And why should a Speaker who is not confident of facing a motion for his removal have the right to adjudicate upon the disqualification petitions under the 10th schedule? The manner in which the matter has been examined here and above is on ethical considerations. A constitutional issue, however, must have a constitutional answer. We shall endeavor to deal with the constitutional connotation of the instant issue in the following paragraphs. Just like the other provisions of the Constitution interpreted by us here and above, it would be apposite to ascertain the desired intent of the framers of the Constitution emerging from the Constituent Assembly debates with reference to Article 179 subclause C. The draft Constitution, the present Article 179, was numbered as Article 158. One of the issues debated with reference to draft Article 158C was with reference to the words all the then members of the Assembly used therein. The above words were used to define those who would participate in the motion for the removal of the Speaker. Needless to mention that the said words were retained in the final draft in Article 179C. One of the members of the Constituent Assembly had suggested substitution of the above words by the words the members of the Assembly present and voting under so-and-so. Mr. Mohammad Tahir, sir, I beg to move that in clause C of Article 158 for the words all the then members of the Assembly, the words the members of the Assembly present and voting be substituted. Clause C runs as follows. Clause C may be removed from his office for incapacity or want of confidence by a resolution of the Assembly passed by a majority of all the then members of the Assembly. Sir, so far as I can understand the meaning of the wording, all the then members of the Assembly, it includes all the members of the Assembly. Supposing a House is composed of 300 members, then it will mean all the 300 members of the Assembly, that is 300. Supposing 50 members of the House are not present in the House, then those members will not have the right to give their vote so far as the question is concerned. Therefore, I think that it would be better that this matter should be considered by only those members who are present in the Assembly and who can vote in the matter. In this phrase, all the then members of the Assembly means the members who are present in the Assembly, then I have no objection. If it means all the members of which the House is composed, I think it is not desirable to keep the clause as it stands. With these words, I move my amendment. The Constituent Assembly debates do not appear to have recorded any discussion on the above amendment. The decision on the proposed amendment was, however, minuted as under. Mr. President, the question is that in clause C of Article 158 for words all the members of the assembly, the words all the then members of the assembly, the words the members of the assembly present and voting be substituted. The amendment was negative. It is apparent that the Constituent Assembly chose to retain the words all the then members of the Assembly and declined to substitute them with the words the members of the Assembly present and voting. We are of the view that the acceptance of one set of words and the rejection of the suggested substitution would effectively render a constitutional answer to the issue in hand. Article 179 subclause C provides that a speaker or deputy speaker may be removed from his office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. A notice of resolution for the removal of the Speaker or the Deputy Speaker of the Assembly would therefore have to be passed by a majority of all the then members of the Assembly. The words all the then members include in Article 179 subclause C are a conscious date. If the words all the then members are excluded from the clause C of Article 179, it would affirm the interpretation which the appellants wish us to adopt. The connotation placed by the appellants would legitimize the action of the Speaker in going ahead with the proceedings under the 10th schedule, even though a notice of resolution for his removal from the office of the Speaker was pending. The words all the then members were consciously added to Article 179C and their substitution was not accepted by the Constituent Assembly. We are satisfied that the words passed by a majority of all the then members of the Assembly would prohibit the Speaker from going ahead with the disqualification proceedings under the 10th schedule, as the same would negate the effects of the words all the then members after the disqualification of one or more MLAs from the House. The words all the then members demonstrate an expression of definiteness. Any change in the strength and composition of the Assembly by disqualifying sitting MLAs for the period during which the notice of resolution for the removal of the Speaker or the Deputy Speaker is pending would conflict with the express mandate of Article 179C, requiring all the then members to determine the right of the Speaker to continue. It would also be relevant to notice that the 10th schedule was inserted by the Constitution's 73rd Amendment Act 1992, with effect on 24/4/93. The purpose sought to be achieved through the 10th schedule is clear and unambiguous. The same is unrelated to and distinct from the purpose sought to be achieved through Article 179C. Neither of the above provisions can be seen as conflicting with the other. Both must therefore freely operate within their individual constitutional space. Each of them will have to be interpreted in a manner as would serve the objects sought to be achieved without treading into the constitutional expanse of the other. The interpretation would have to be such as would maintain constitutional purpose and harmony. We would now venture to examine the instant issue from the above perspective in the following paragraph. If a speaker survives the vote on a motion for his removal from the office of the Speaker, he would still be able to adjudicate upon the disqualification petitions under the 10th schedule. The process of judicial review cannot alter the above position. But if a disqualification petition is accepted by the Speaker, the disqualified MLAs will have no right to participate in the motion moved by the Speaker under Article 179C. A disqualified MLA, as we all know, can assail the order of his disqualification by way of judicial review. If he succeeds and his disqualification from the House is set aside, such a disqualified MLA would be deprived of an opportunity to participate in the motion against the Speaker under Article 179C. In this situation, the process of judicial review can also alter the position if a disqualification order passed by the Speaker is set aside by a court of competent jurisdiction. In the event of an MLA having been disqualified by the Speaker, the notice of resolution for the removal of the Speaker would surely be dealt with and will be disposed of during the period when the MLA concerned stood disqualified. Alternatively, if an MLA has not been disqualified when the motion for the removal of the Speaker is taken up, he would have the right to vote on the motion pertaining to removal of the Speaker, whereafter the petition for his own disqualification would certainly be considered and decided by the Speaker. It is apparent that the difficulty arises only if the disqualification petition is taken up first and the motion for the removal of the Speaker is taken up thereafter. The possibility of a disqualification petition being decided on political considerations rather than on merits cannot be ignored. In fact, that is a real possibility. Therefore, while it will not be adversely affect the Speaker if he faces the motion of his own removal from the office of the Speaker before dealing with the disqualification petitions, it could seriously prejudice MLAs facing disqualification if petitions for their disqualifications are taken up and dealt with first. The adoption of the former course would also result in meaningfully giving effect to the words all the then members used in Article 179C as discussed in foregoing paragraph. This interpretation would also purposefully give effect to the rejection of the amendment suggested during the Constituent Assembly debates that the motion for the removal of the Speaker should be the majority of the members of the present and voting. This interpretation would also result in disregarding the retention of the words all the then members of the Assembly in Article 179C. If the Speaker faces the motion of his own removal first, both constitutional provisions would have their independent operational space preserved. None of the constitutional provisions concerned would interfere with the free functionality of the other, nor would one usurp the scheme postulated for the other. We therefore are of the view that the constitutional purpose and constitutional harmony would be maintained and preserved if a speaker refrains from adjudication of a petition for disqualification under the 10th schedule, while his own position as the speaker is under challenge. This would also allow the two provisions of Article 179C and the 10th schedule to operate in their individual constitutional space without encroaching on the other. Now, kindly have my lords paragraph 233.
PDF page 1162.
PDF page 1162, where Justice Mishra's opinion, the relevant paras are. Para 233.
What's the PDF page?
PDF page 1162.
1162.
1166.
Thanks.
233.
Para 233.
1166.
1166, my lords, I'm so sorry. 1166. May I? There can be myriad situations in a democracy. The Constitution as an organic instrument has to be interpreted to meet all exigency. It has to have flexibility. Assuming the requisite members express their intention to move the resolution for removal of the speaker from the office, and immediately the speaker on a complaint initiates action under the 10th schedule, and as the resolution against the speaker cannot be moved unless 14 days notice period expires, the members can be disqualified within the said period and the speaker would gain an advantage. Thus, it can result in a situation of constitutional conflict, that is the conflict between the status of the speaker conferred by the Constitution and the position he has been given after the constitutional amendment. The final arbiters have trusted him regard being had to his constitutional status. It is the constitutional trust. Therefore, there should be perceptibility of absence of conflict. That apart, it will not be in harmony with 179C or the constitutional norm. It would also cause discord with the language employed in the said article. The founding fathers had deliberately retained the words all the then members by negative proposed amendment. The purpose of not accepting the amendment is to preserve the constitutional control over the situation. In this regard, I may usefully refer to Article 189 of the Constitution. It provides for voting in the House, power of houses to act notwithstanding vacancies and quorum. Clause 1 of 189 stipulates that save as otherwise provided in the Constitution, all questions at any sitting of a House of the legislature of a state shall be determined by a majority of the votes of the members present in voting, other than Speaker or Chairman or person acting as such. The said clause also provides the Speaker or Chairman or the person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an equality of votes. The said clause thus clearly states about the majority of the votes of the members present in voting, and secondly, it empowers the Speaker to exercise his power of voting in case of equality of votes. In contradistinction to the same, Article 181 provides that the Speaker or the Deputy Speaker is not to preside while resolution of his removal from the office is under consideration, and he is entitled to vote in the first instance on such resolution, but not in the case of an equality of votes. Article 181(2) is relevant for the present purposes, reads as follows. Well, that I've already read. I'll come to the next paragraph. 235. The purpose of referring the said article is to highlight the nature of participation of the Speaker when the question of his removal arises. It is clearly different. Under the Constitution, he is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution and especially keeping in view the language employed in first proviso to 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest that the resolution is moved. In this regard, it is essential to understand the character of the 10th schedule. The 10th schedule to the Constitution has conferred the adjudicatory powers on the Speaker. While deliberating on the constitutionality of the said schedule, the majority in Kyoto Honolulu has stated that the Speaker, Chairman, while exercising powers and discharging functions under 10th schedule, act as tribunal, adjudicating rights and obligations under the 10th schedule, and their decision in that capacity are amenable to judicial review. However, having regard to constitutional scheme in the 10th schedule, a judicial review should not cover any stage prior to the making of the decision by the Speaker's chairman. Having regard to the constitutional intendment and the status of the repository of the adjudicatory power, no quid timid action are permissible. The only exception for any interlocutory interference being cases of interlocutory disqualification or suspensions which may have grave, immediate and irreversible repercussions and consequences. That para 6(1) of the 10th schedule, to the extent it seeks to impart a finality to the decision of the Speaker, Chairman, is valid, but the concept of statutory finality embodied in para 6(1) does not detract from or abrogate judicial review under 136, 226 and 227 of the Constitution, insofar as infirmities based on violations of constitutional mandates, malafide, non-compliance with the rules of natural justice and perversity are concerned. That the deeming provisions in para 6(2) of 10th schedule attract an immunity analogous to Article 122(1) and 212(1) of the Constitution, as understood and explained in Keshav Singh's case, to protect the validity of proceedings from mere irregularities of procedure. The deeming provision having regard to the words be deemed to be proceedings in Parliament or proceedings in the legislature of a state confines the scope of fiction accordingly. That the contention that the investiture of adjudicatory functions and the Speaker, Chairman would by itself vitiate the provisions on the ground of likelihood of political bias is unsound and is rejected. The Speaker, Chairman hold a pivotal position in the scheme of parliamentary democracy and are guardians of the rights and privileges of the House. They are expected to and take far-reaching decisions in functioning of parliamentary democracy. Stature of power to adjudicate questions under the 10th schedule in such constitutional functionaries should not be considered exceptionable. The aforesaid reasoning eloquently speaks of the power, position and status of office of the Speaker enjoys under the Constitution. It also states that the scope of the fiction court has constricted the power of judicial review and restricted it to the stage, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority and jurisdiction, exercises the power of constitutional adjudication. The concept of constitutional adjudication has constitutional value in a parliamentary democracy, and constitutional values sustain the democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. The Speaker, when functions as a tribunal, has the jurisdiction authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of 10th schedule by constitutional amendment is required to be harmoniously construed with Article 179C. Both the provisions of the Constitution are meant to subserve the purposes of substance of democracy, which is a basic feature of the Constitution. The majority in Manoj Narula versus Union of India, where speaking about the democracy is opined, the democracy in India is a product of the rule of law, and it is not only a political philosophy, but also an embodiment of constitutional philosophy. Thus, regard being had to the language employed in Article 179C of the Constitution and the role prescribed to the Speaker under the 10th schedule, it is necessary that the Speaker as a tribunal has to complete detachment and perceive impartiality. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of 179C, and the said interpretation serves the litmus test of sustained democracy founded on rule of law. And founding fathers had also intended that the constitutional value, trust and morality unequivocally so suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the 10th schedule of the Constitution after intention to remove it from the office is moved. The 14 days period being mandatory, the word all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command is to have confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution, and it clearly brings in harmony between constitutional confidence or trust and the constitutional control. Be it stated, the position has to remain the same even after introduction of the 10th schedule to sustain the robust vitality of our growing Constitution, and it embraces the seminal spirit of rule of law that controls all powers, even the prerogative powers. Now just show me the Dr. Ambedkar's. Just in continuance, because your lordships have also read the Constituent Assembly debates on the then members, there is another portion that I wanted to show to your lordships, which is page 196 is what PDF page?
It's the compilation of statute.
You would rather come in.
Starts at page 193.
The Constitution in 181, the restraints which operate on the Speaker operate when a motion for his removal is under consideration. All right. Now, what has been done in Nabam Rebia is to read in certain implied restraints based on a harmonious reading of the 10th schedule on the and these provisions of the Constitution. But those restraints, if we have to be logical, those restraints which we bring in by an implied reading of limitations on the power of the Speaker must also commence when a motion for his removal is under consideration. Right? Now, when is a motion for the removal of the Speaker under consideration? Stage 1 is the proviso to 179C, when a motion for the
A notice.
when notice has been given of the intention to move a resolution.
Yes.
179C proviso reflects the intention of a member
Right.
to move a resolution
Right.
for the removal of the Speaker.
Right.
So I'm going to move a resolution. I have an intent here and now
Right.
to move a resolution for his removal. As soon as that is given and a period of 14 days has expired, then the rule 11 says that on the expiry of 14 days, the Speaker thereafter has to convene
Right.
the House,
Right.
and the notice has to be read.
Right.
If the notice is, if it is supported by 29 members,
Correct.
then leave shall be granted.
Right.
Once leave is granted,
Within
then not less than
7 days.
7 days have to be given,
Absolutely.
after
That's
which the motion will be taken up for consideration.
Absolutely.
Therefore, the reading of these rules would indicate that the motion for the removal, the intent, the notice which is given of the intent to move the resolution, the motion is under consideration only after the House has granted leave, and upon the grant of leave, the motion is taken up for consideration after a period of 7 days.
Right.
Because 7 days has to be
Right.
Now, can we say that the motion is under consideration at any stage prior to the grant of leave? We need not go as far as to say that the motion is not under consideration until 7 days have elapsed. That 7 days is for him to really have sufficient opportunity.
Correct.
But the grant of leave is a critical facet, because it is upon the grant of leave that the motion then
Exactly.
is to be considered by the House.
So just
It cannot be considered until the expiry of 7 days, but after the expiry of 7 days, then the Speaker,
So just
is
to
on notice
add to what,
to be considered.
what my lord said, just to add to what my lord said in all humility, that is exactly.
Because prior to the grant of leave, if you don't muster up 29 members,
Yes, that's
this.
Right, but what Justice
the
Mishra deals
requirement
with,
is absent.
what Justice Mishra deals with in para 23 is that when that notice is given between that period of 14 days, if the composition is altered, nothing stops him from doing it. Anyone who will ostensibly, as per his assessment, vote against him, in those 14 days from the moment intention is expressed, till it fructifies in a resolution or a motion is altered, what happens? Manoj, that's exactly the position that Justice Mishra deals with. We can't say that a speaker who wants to work towards unconstitutional ends will only start working towards unconstitutional ends after a resolution or a motion is taken up, and will not work towards them from the date the intention for his removal is expressed under 79C proviso. He will not wait for a motion to be moved 7 days, 14 days, they will follow. That's the procedure under the Constitution and the Assembly rules. That speaker will start working the day the intention is given to alter the pool. And that is what Justice Mishra says, that how do we protect that period of 14 days before? Your lordships are absolutely right the way your lordships summed it up. But for that period from 179C to 181 and Rule 11, how will the composition of the then members, and this does not include 191 and 1021.
If we are
This is given, it is the speaker who is in charge.
Another point really is that to what extent do we have a certain discretion to tighten up Nabam Rebia?
That's what you say.
Because we are also constitution bench.
But, my lords, may I just add, that is why I respectfully
Without making a reference, can we then
my lords, this does
Tighten it up.
tighten it up a little bit?
not require a
Tighten it up a little bit. We got the thrust of your argument. Therefore, we may not go as far as to say that Nabam is wrong.
Yes.
But is it not necessary a little bit to just tighten up a little?
Because all
I'm
period,
thinking aloud, my lords. Your lordships thinks it needs to be tweaked and tightened as far as the procedural part is concerned.
Right.
Your lordships may consider that.
That's what
The issue, and that's what I've been in all.
Yes, Mr. Kaul, what we are trying to, we just want your assistance on this. Can we do it in a bench of 5?
My lords, why?
Maninder is saying, no, you can't do it.
No, my lords, there is nothing contrary. Your lordships cannot.
then we
do
have to
something
refer it.
Contrary.
Maninder Singh, we have to refer to 7 then.
No, Mr. Kaul.
Can we do it?
Mr. Kaul, listen. Justice Kher and Justice Mishra specifically, correct, has taken the view, one view, that once the notice is issued for disqualification, correct, he has to stay his hand.
Yes.
Speaker has not to do anything.
Yes.
Now, if we take a somewhat different view, listen, somewhat different view, correct, that, no, not this stage, but granting the leave can be a stage for the purpose of disqualification to her staying the hands, then can we do it or 7?
No, my lords, I'm sorry. I didn't, what I meant was that as far as the moment notice or intention is expressed to remove a speaker under 179C proviso, and as captured by Justice Mishra in para 233 is concerned, the clock stops ticking. I'm only on the limited issue that if these kind of examples are given, that a notice is moved on the large section. I'm only on that. I didn't mean that your lordships can tweak what Nabam Rebia is at. Yes.
We need not go into that at all. We are now on whether, you see, because there are 2 places in Justice Kher's judgment where the learned judge uses the expression, while a notice of resolution for his own removal from the office of the speaker is pending. That's the specific language which the learned judge uses. Para 189. Just see para 189
Yes.
at page 1145. Yes, let's focus only on those 2 lines.
Yes.
189, where the learned judge deals with as a matter of first principles, the ethicality or the morality, as he says.
Yes.
189, the action of the speaker in continuing with one or more disqualification petitions under the 10th schedule, whilst a notice of resolution for his own removal from the office of the speaker is pending, would appear to be unfair. We'll then go to the next part where he says that. I'll just take you through that as well. The next part is para 193 at page 1149.
Yes.
We are therefore of the view that constitutional purpose and constitutional harmony would be maintained and preserved.
Because I'm sorry, Placitum, I will.
Yes, Placitum A at your internal page 1136.
We are therefore, my lord, is that?
Yeah, of the view that constitutional purpose and constitutional harmony would be maintained and preserved if a speaker refrains from adjudication of a petition for disqualification under the 10th schedule while his own position as a speaker is under challenge. And 194. We hereby hold that it would be constitutionally impermissible for a speaker to adjudicate upon the disqualification petitions under 10th schedule, while a notice of resolution for his own removal from the office of speaker is pending. All right, these are the two. So 189 and 194, which we saw. Now Justice Mishra at page 238, we go to 1166, para 238.
First, if your lordship are again,
Just one
read
second.
233 also.
Sorry?
233 will be in continuation of what your lordships are saying.
Right.
Please see 233 for a minute.
Yeah, that's what I'm saying, 233.
Yes.
233.
Yes.
And
Can I read 233 for a minute?
that is a rationale. That's the rationale. We're now looking at what is the bottom line that they hold. You're right, 233 gives us a rationale, which you have taken us through as well, independently of this. Now, if you just see what is it that Justice Mishra ultimately holds, he says in para 238, one second, I just marked it here.
Five, 1155.
Yes.
PDF
1155 para 238.
That's
when there is an placitum G, when there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. So both.
How do if we see there are Article 79, it speaks of 14 days notice.
Of the intention to move.
Intention to move. Now, crucial expression is move. Moving from 179, when we come to the rule creates a further period. It creates 4 segments. First, it incorporates 179, that 14 days notice. Then it provides speaker reading it out. And then 111 also provides as soon as maybe after that, the second period comes in. Then it contemplates 29 members standing.
And leave being granted.
And then after they stand 29, then motion comes into play, and then 7 days period comes into play. So these are by virtue of the rule. On interpretation of the constitution, we may perhaps ignore, I don't really know. We can leave it at, but then the crucial point will be from the date of the motion, intention to move. If we take the move to be the same time when 29 members stand, and then the speaker takes a decision that the motion is moved and 7 days comes into play, then that period will be the crucial period, because all aspects prior to that are incoherent. They may move, they may not move.
But my lords, but
all that is incoherent, may not even come into existence.
Really, if it doesn't.
1 minute.
Yes.
They may not come into existence, as so many examples have been given. But this particular act of the speaker identifying 29 members having approved of it, then his mandate, his obligation to complete it within 7 days comes into play. It is that crucial period which should perhaps have. And second question is whether we can give that kind of an interpretation without referring to 7 days.
No, my lords, I was saying in a different context, as far as this starting point is concerned, my contention will still be, it is final. It has to be the stage of the notice. That cannot be tinkered with, my lords.
So that is.
No, that is okay, counsel. But what is pointed out is, suppose we want to change something, can we do it under as a 5-judge or 7-judge?
My lords, with great respect, also depends on what your lordships wants to change. That is why I put up, with great respect, I say that, my lords, if your lordships are further adding to the checks and balances which are there, that is one thing, which may not be contrary to Nabam Rebia at all.
No, but it is, because these two sentences which I read out to you,
my lords, that's why
say that the cloud on the speakers deciding starts the moment you notice under the proviso.
So, my lords, the reason I'm supporting that is by this, that please, and that is what Justice Mishra deals with. The moment what follows rule, no resolution, motion, 29 members are all a procedure provided subsequent to the intention to remove a speaker under the constitution. Those are procedural compliances that if you do it in this manner, the speaker will be removed. That is quite different from the problem which Nabam Rebia and Justice Mishra are addressing. That is that till that procedure reaches its culmination, it's after all a continuation of procedure for 179, 181, Rule 11, Rule 18, Rule 20 is a culmination of the procedure. Till that procedure culminates and is put to vote, if a speaker who is all in all under the 10th schedule utilizes that time and alters the pool, and if the only argument is it is inchoate, if the only argument taken is that we do not do it, may or may not happen. Can that be an answer? Suppose it does happen. I'm reversing it. Suppose it does happen. The speaker who between the day the notice is given and it reaches its fructification in the manner the rules and the constitution provides, completely alters the house. And your lordship says the clock starts ticking only when 29 members rise, it's taken up, and that is when the motion is to be considered. Then the damage is done. And why will
हम लोग So, Sibal, Mr. Call, Mr. Solicitor, what we'll do is we just take a break for about 5 or 10 minutes. We want to discuss something.
Well, as I just
ourselves on
also
the way
wanted to place something before your notice, before. I don't mind, Malaj. I want to place something.
We just want to, yes, we are, of course, we are not concluding the argument. We just come back.
Because
Otherwise we are sitting on the bench and
I see. No, I understand that. I was only saying.
we'll have the pleasure of talking with each other without the mic.
Without the absolutely. Absolutely. Deeply obliged.
We'll just come back in touch.
Yes, Malaj.
So what we would suggest is that if all of you can conclude today on whether the reference should be made or shouldn't be made, because now we've substantially heard arguments, so just now Mr. Jetlani, Mr. Mehta and Mr.
No,
Mantra.
just give me 10 minutes and I'll conclude.
No, we have heard you, Council. We let us
No, just-
5 minutes them.
just
I'll
two
also need some
submissions and
time.
Yes.
On why a reference should be...
Yes, Manoj, because there are some things that have been said which I need to clarify, Manoj.
I'll just wrap up, my lords, very quickly.
Because-
My lords, firstly, there is no reason, my lords, for this concern that some one member gives a notice and it indefinitely lies because Rule 11.
Mr. Council already argued all these things.
I'll try to be.
What your point was?
I'll try to be as crisp as possible and finish as quickly as I can. So that is taken care of. B, the constitution doesn't make any difference between one member making a notice or 20 or 25 making a notice. The conflict of interest starts not merely, my lords, at the stage when 29 members rise to support a motion. Conflict of interest starts the date and intention to initiate a resolution for removal. The words used in 79C proviso is intention to initiate a resolution for removal. The conflict of interest starts on that date. Conflict of interest doesn't cease to happen for 14 days and starts on the 15th day. 7 days, 14 days, 29 MLAs standing is all procedure after that, which is required. So intent of Nabam Rebia was at what stage will the conflict of interest be stopped, and that is what it sought to do there, my lords, in that case. As far as facts of Nabam are concerned, if your lords want, I'll briefly give. According to me, in the facts of Nabam, disqualification of members specifically arose. It is wrong to suggest that it was an issue only concerning the powers of the governor. If your lordships wants, I can give those 5 facts immediately to your lordships. Those are of some relevance because this was an argument made that never dealt with disqualification of members. I just use my... Well, some 4 or 5 facts. On 19/11/2015, a notice for removal of Speaker of the Assembly was moved by 13 MLAs.
What is the date?
On 19/11/2015, or rather, my lord, I'll start before that, a notice of resolution for removal of the Deputy Speaker was moved by 16 MLAs on 16/11/2015. First, on 19/11/2015, a notice of resolution for removal of Speaker of the Assembly was moved by 13 MLAs. The Chief Whip of the Congress filed a disqualification petition against 14 MLAs of the INC on 7/12/2015, including the Deputy Speaker. The Governor issued an order dated 9/12/2015 to prepone the session of the Assembly from 14/1/2016 to 16/12/2015, and it made removal of the Speaker as the first item for consideration. The Council of Ministers was convened on 14/12/2015, and it resolved that the order of the Governor was unconstitutional. The disqualification proceedings against 14 MLAs and descendant group were taken up for hearing by the Speaker, and an ex parte disqualification order was passed by the Speaker. Thereafter, the Deputy Speaker conducted the proceedings of the Assembly outside the official Assembly premises and passed an order quashing the Speaker's order for postponement of the session to its original date. And the Governor's order for session to be conducted on such and such date was reinstated. A resolution to remove the Speaker was also adopted by the Assembly on 16/11. So all that I am respectfully submitting, my lords, is the Governor's exercise of power was one part, the Speaker taking up disqualification petitions while his own removal was pending was a specific issue, and thus the court commented on it. It is wrong to say that that was not an issue. As far as my lords had also put a question to me before lunch, as far as a live issue is concerned, my lords, of course, our contention will still remain that on 27th, all that the court said was give them more time. There is no indication of any principle of Nabam Rebia being incorporated, but be that as it may. In any case, on 29th, when the floor test was refused, Nabam Rebia was not in the picture. You refused to take the floor test, which your lordships have time and again said, and if that is so, The nature of petitions that you've now moved and which Mr. Salve touched upon in the morning,
Already-
all those matters on Article 32. Can you today want this court as the court of first instance to decide all those issues, my lords, in this matter?
You're
So
correct.
my respectful submission, my lords, is that Nabam Rebia is correct law, requires no tinkering or interference, and does not require a reference, my lords. I'm very, very grateful, my lords, extremely.
Yes, Mr.
I'll take, my lord, only 10 minutes. But I appear for the governor. My lord, on the question of marriage, your lordships are not doing, and I am not supposed to address on the question of marriage. But I'll just point out the flip side of the exercise which the petitioners have, my lord, called upon your lordships to undertake, merely as an academic exercise. And the focal point of the entire defection law, that is the real sovereign, the elector, the voter, my lord, doesn't find place in any of these arguments. My lord, I just wish to, my lord, bring that fact to your lordship's notice. My lord, we do not have a two-party system. But India is a multi-party democracy. Something will go into the root of this issue when I point out, my lord, the constitutional dilemma which your lordships would eventually face, my lord, if this is raised, my lord, and my lord, sought to be answered purely academically. Lord, we have a multi-party democracy. Multi-party democracy would necessarily mean that now we are in the era of alliances. Lord, constitution always evolves based upon your lordship's experience of how the constitution has worked so far. How is it being used, abused, misused, not used, etc. In a multi-party democracy, there are two types of alliances, Lord, which are contemplated. One is pre-poll alliance and another is post-poll alliance. Post-poll alliance is usually, my lord, an opportunistic alliance, my lord, to complete the numbers. But pre-poll alliances are always principled, my lord, alliances. And that is where, my lord, 4 paragraphs from Quixote, my lord, I would read after giving the preface of what I am driving at. Lord, in a pre-poll alliance, Lord, taking facts of this particular case, Lord, there was a pre-poll alliance between 2 political parties. Lord, I'll name the parties because all parties, my lord, are subject matter, my lord, between BJP and Shiv Sena. As Quixote, my lord, explains, when you go before the voter, you don't go as an individual candidate. You go as a representative representing a particular ideology. A representative who will go and say that this is our shared belief, this is our shared agenda. Don't vote for the other party for A, B, C, D, E reasons which are negative for the development, for your own upliftment, etc., etc. The voter does not vote for individuals, but it votes for the ideology and the political philosophy which, my lord, the parties project. Lord, here what has happened, my lord, we hear the expression horse trading in all defection matter. Here, the leader of the stable, my lord, took the stable away and started, my lord, he formed the government with those against whom, my lord, they contested the election, and a negative vote was given by the electorate against a particular party. Now, my lord, we come to, my lord, Quixote Holohan, my lord, in this background.
No, but Mr. Mehta, how can the governor be heard to say all this?
I am
on the formation of the government between the
I am absolutely not on the morality part of it.
How can the governor have anything to say on
Lord, your lordships, my lord, stopped me a little early, my lord. I was coming to Quixote.
Yes.
Lord, what Quixote does was, Lord, when Quixote, my lord, was considering the constitutional validity of Schedule 10, there were 2 contentions raised. And why, my lord, I entered into the facts, not as a political argument.
When they formed government, the government
not on that, Lord, kindly allow me.
Governor asked them to have a trust vote. They got a trust vote.
Lord, let me make it clear. I am not arguing the list between the parties. I am arguing why Nabam, Lord, is a correct law. And my preface on facts is necessary so that I can point out, my lord, if your lordships would like, my lord, me to conclude early because of constraint of time, I can conclude, my lord.
No, but we are only saying that the governor should not enter the political.
I am not entering political arena.
Yes.
I am not entering. Why I am saying this, my lord? And my lord, that's why, my lord, I made a preface that there is a constitutional argument flowing from, my lord, these facts. And these facts may occur, my lord, in different variety of situations at various, my lord, stages in various states. And your lordship will not confine your examination to the facts of this case. Now, my lord, when Quixote Hilohan was examining the constitutional validity, there were two contentions which were raised by the petitioners who were challenging the validity. A, that this negates the freedom of expression of the electors, my lord, that is freedom of expression of the one who is elected member of Legislative Assembly, because I, as an elected person, I means not governor, but kindly take it as an academic argument, my lord, as a constitutional argument. I, as an elected person, my lord, represent the views of my electors. So the argument was that unless and until, my lord, I express my views, you are curtailing 19(1)(a) rights. The second argument was right to conscience. Right to conscience. My lord, kindly see, my lord, some of the paragraphs in this context, my lord, if, in my lord, the purpose of my giving, my lord, this background of facts, my lord, which your lordship prima facie found to be, my lord, entering into the merits, which I never intended to. My lord, please come to, my lord, compilation, judgment compilation, PDF 94. Because here, my lord, the pleadings are that we couldn't go before our electorate. We couldn't go. I'm conscious, my lord, what my role is, and I'm conscious, my lord, what I must point out to your lord.
Yes, yes.
For arriving at a correct conclusion, constitutionally. Page 91, my lord, PDF 94.
Page 94. Yes.
Para 30?
Para 13, my lord. My lord, the argument, my lord, the submission would be that 10th schedule is, my lord, for preventing unprincipled defections and not for the purpose of stifling a genuine dissent. And, my lord, in a multi-party democracy, my lord, your lordship would encounter cases where, in principles, the elected persons will have to go against the leader, my lord, not against the party. And that's what, my lord, the weapon of Article Chapter 10 is not to legitimate dissent. That, all right, you want to move this motion, let me remove you. I will decide, my lord, kindly see, this is a very, very serious issue. I am the speaker, I have the power to remove, and I will decide the electoral college who will vote in my no confidence motion. That is what is prevented, not under Article 181, etc. my lord. That is also one of the factors considered. But yes, propriety, Lord, please speak 13. These provisions in the 10th schedule give recognition to the role of political parties in the political process. A political party goes before the electorate with a particular program and it sets up candidates at the election on the basis of such program. A person who gets elected as a candidate set up by a political party is so elected on the basis of the program of the political party. The provisions of Para 2(1)(a) proceeds on the premise that political propriety and morality demand that if such a person, after the election, changes his affiliation and leaves the political party which had set him up as candidate at the election, then he should give up his membership of the legislature and go back to the electorate. The same yardstick is applied to a person who is elected as an independent. Kindly come to 97, PDF 97. Lord, one of the contentions, my lord, A, my lord, immediately after, well, I'll read the A. The Constitution 52nd Amendment Act, insofar as it seeks to introduce the 10th schedule, is destructive of the basic structure of the Constitution as it is violative of fundamental principles of parliamentary democracy, a basic feature of Indian constitutionalism, and it's destructive of the freedom of speech, right to dissent and freedom of conscience, as the provisions of the 10th schedule seek to penalize and disqualify elected representatives from the exercise of their rights and freedoms, which are essential to the sustenance of parliamentary democracy. Lord, kindly see 100. Lord, these are my submissions. I am not making, Lord, submissions on behalf of the governor. These are, Lord, the issues your Lordship will have to bear in mind while judging the correctness of Nadia. 30, Lord. It was strenuously contended by Sri Jethmalani and Sri Sharma that provisions of the 10th schedule constitute a flagrant violation of those fundamental principles and values which are basic to the sustenance of very system of parliamentary democracy. The 10th schedule, it is urged, negates those very foundational assumptions of parliamentary democracy, of freedom of speech, of the right to dissent, and the freedom of conscience. That I'll not be able to go before my electorate because I went with a particular ideology and now I'm sitting with an opposite ideology. I'm not, my lord, on facts of this case. Right to conscience, my lord, is a right pleaded while challenging the constitutional validity of these provisions, and if your lordship were to lead power into the speaker to disqualify people, even in case of a legitimate dissent, exercising the right to conscience, not possibly, your lordship may have to revisit such challenges if made.
How is the governor arguing all this? I do not.
105. My learned friend, I expect him to, my lord.
Either, my lord, this statement should be recorded as the submissions of the governor.
No,
we'll accept
these are
that.
my submissions.
But he can't have an independent status, my lord, independent of the governor. He's not arguing for the governor and he's saying, I am arguing in my individual capacity. What capacity?
Lord, I'll not, Lord.
No, it's not fair. It's not fair.
Lord,
because if I start talking about conscience,
say one
thing, then I can say, party in power has a fundamental right to buy off people. Does that party in power have that right?
That's all right.
Let's not make allegations.
Confine yourself.
Kindly, my lord, my learned friend, my lord, interrupted at a very right moment. He should have interrupted when I reached para 44. Should have.
Para 40.
I'll interrupt
yes.
you again, don't worry.
But these are all submissions, right?
Yes, my lord. Lord, now, my lord, these are the, my lord, findings.
Para
This is how, my lord, the court rejected these submissions. Your lordships would be, by conferring power on the speaker to disqualify within that 14 days period, with which, my lord, I have nothing to say, would be permitting, my lord, even a legitimate dissent. My lord, I am not on buying and selling and horse trading. I am on a question where, Lord, again, coming to the facts of the case when
according to you, Mr. Solicitor, what do you suggest with respect to the time frame, time within which this injunction against the speaker should apply?
Lord, it is for them to answer, my lord, because they have the list between the.
But we take it that therefore your contention is that it must.
I'll answer.
That the cloud must go back to the date when an intent to remove the speaker is given by the form of a notice.
Right. My lord, the counter answer, my lord, question which I already posed before your lordship for consideration. My lord, suppose I went.
Is it your case that the bar on the speaker adjudicating on a petition for disqualification attaches the moment in notice within the meaning of the proviso to Article 79, 179 is
correct. The reason is this. Look, the reason is this. No, forget the facts of this case. Suppose there is no dissent amongst the party members, but majority of the party members, maybe 90 out of 100, wants to remove only the speaker. Only the speaker. There is no, my lord, loss of confidence amongst the leader, namely the chief minister. He has done something extremely wrong and everybody wants that he is not stepping down. Let us remove him by a motion of no confidence. What he needs is one application, my lord, and he can remove 99%, disqualify 99%, saying that I am the elected speaker. I was elected under a whip issued by your political party, and this is how. Ultimately, it may be different thing that the political party may condone that defiance of the whip. But your lordships would be leaving everything at the sweet will and discretion of the speaker, who will be entitled to tailor-make his own voters' list, who will vote in case of his electoral, in his vote of confidence. That's the flip side I wanted to point out.
That's the danger.
No,
That's the danger I'm pointing out, my lord, and kindly appreciate, my lord. Again,
that is what Justice Mishra has also observed.
correct,
What was the reasoning given by Justice Mishra?
That, my lord, in my respectful submission, my lord, and subject to appealing to your lordships, is a correct reasoning. Lord, kindly appreciate, my lord, here, again, not being political. I am giving an example, my lord, to, my lord, fit into this constitutional scheme. Out of 55 elected persons of a party, 40 people want the speaker to go. There is a lack of confidence. But the speaker says and the chief minister says, which, my lord, prima facie fell from your lordship also, that the chief minister did not face because there was no disqualification, meaning thereby the chief minister would have faced the vote of confidence only after 40 people are in and 15 remains. Lord, that perhaps
We'll formulate your point like this. The speaker should not be permitted to tailor-make the electoral college, which has the power to vote him out of office. That's the point.
That's argument. Another argument. Lord, suppose even if I were to say, well, because I don't have the list, that all right, read the provision that the moment a motion is brought to his notice, it has to be moved and, my lord, culminated in either this, Lord, motion losing or motion succeeding within a particular time. Lord, your lordships may do that. Lord, suppose I am suggesting. Kindly, my lord, examine. Suppose the speaker himself doesn't call the meeting and continue to exercise the powers under the 10th schedule. Lord, the majority of the members give a motion of no confidence to the speaker. It is for the speaker to convene the house. He doesn't convene the house. He doesn't bring that motion to the assembly. And in the meanwhile, my lord, he starts at the behest of one gentleman, my lord, proceedings. These are the flip sides. Lord, therefore, the question is, my lord, in facts of this case, Lord, does the question of correctness of Nabam Arabia arise at all? Lord, mere
I just speak what I had said earlier. Your submission is that the speaker should not be permitted to alter the composition of the legislative body, which has the power to vote him out of office.
Correct.
That's the long and short of it.
My lord, last submission, and my lord, kindly, this again, my lord, is my worry as an officer of the court, my lord. Lord, whenever you say,
is being questioned.
whenever my learned friend may enter into politics and governor and how, I am on constitutional principles. My lord, my worry is this. What is democratic principles? If I am elected in the house, I am elected as a leader of legislature party. Correct? My being a leader of the legislature party necessarily inherits my duty to continue to earn their confidence throughout my tenure. If I have my person as a speaker, then my accountability to the elected MLAs goes, my lord, because I will know that the moment somebody says that we have lost confidence in the chief minister, I'll be able to trigger 10th schedule through the speaker, and that remains, my lord, as a sword hanging. Therefore, I say 10th schedule is not a weapon to stifle a bona fide legitimate dissent. It is a weapon to control unprincipled defection. Therefore, if your lordship were to go into the facts of this case, the question is, does that fact arise here?
That's a different issue.
It's an academic exercise, very intellectual debate and very healthy debate. My learned friend also raised the level of the debate to a constitutional level. But that would eventually be an academic debate. Suppose your lordship were to say that Nabam is not a good law. I don't wish to argue, my lord, further. But what relief, my lord, would flow thereafter on the main matter? Nabam is a bad law. Suppose your lordships were, my lord, in a combination of 7 were to hold, my lord. Or your lordships can even say that it is per incurium, whatever, my lord, in this combination. Lord, would it affect the final outcome of the proceedings, my lord, after the several events having already taken over? And if that is, the answer is no, would your lordships, my lord, undertake an academic exercise merely because it is raised.
Okay.
So that's the respectful sir.
You're saying
So, my lord,
Thank you, Mr.
Lord, kindly note this, my lord, this unbridled power takes away the concept of accountability of the leader of the house. Accountability of continuing to have confidence of his constituents, namely the MLAs.
All right.
And Lord, they cannot effectively exercise their freedom of expression and conscience. This is a constitutional argument. Lord, forget, Lord, whether it's made on behalf of A party or B party. That's not the issue. I have not, Lord, it was necessary to give some facts, therefore I have given. Your Lordship's question was right.
Thank you, Mr. Solicitor.
These are
Mr. Jetman.
Lord, I have filed,
Can we,
I'll have filed, my Lord, my written submission, so they may be treated as.
but can we get some little time tomorrow, man? An hour or so for both of us as well.
Hour.
40.
We'll hear Mr. Jetlani and Mr. Maninder Singh all three of you tomorrow. Between all three of you, can we give you half an hour between the three of you so that then Mr. Sibal and
I
Mr.
was tempted to make this request, but I couldn't muster up the courage. My Lord, he mustered. But the role is over.
But because it was 4 o'clock, that's why I mustered it up. Not that I have courage.
Mr. Council, you have asked for the 1 hour, we will grant you 45 minutes. If you don't ask for 45 minutes, you have given 30 minutes.
What we'll do is we'll start soon after the mentioning is over tomorrow.
Very well.
And
I'm so grateful.
we'll give between all three of you, we'll give you half an hour tomorrow. So that then Mr. Sibal
We'll respond and we make it short. We're very pointed. We're not going to waste your Lordship.
Right.
Your Lordship may take it from us.